Okay, I'm going to call to order the zoning board meeting, zoning board of appeals for February 9th, 21. We have a 5-member board tonight. The members that will be attending tonight's meeting are members Steve Leanis, Steve Bernard, Fire Chief Michael Williams, alternate member Bob Pelagi, myself, Chairperson Kenneth Galligan. With us also is our zoning enforcement officer, building superintendent, and clerk of the board, Mr. James Plouffe. The recording secretary is Beth Lacombe. As a notice regarding this public hearing, this hearing is being held virtually and in accordance with the governor's order suspending certain provisions of the open meeting law, general law chapter 30A and 20, relating to the 2020 coronavirus outbreak emergency. The February public meeting of the Zoning Board of Appeals will be open to the public. However, the public and all applicants are encouraged to participate remotely. The meeting will be televised via Brockton Community Access TV. Public comments will be taken via Zoom or by email that have been sent to the building inspector. The comments will be read during the public comment portion of the agenda item. The comment must first state your full name and address, and only the first 2 minutes or so of the comment will be read during the hearing. I would encourage anybody that has any electronic devices, such as a telephone or whatever, to please put it on silent so that it doesn't affect the meeting. Tonight, before we start the meeting, I have one case that has been withdrawn that will not be heard this evening. And that is case number 21-17. The petitioner Hyacinth and Everett Realty Associates LLC, 59 Short Street, Taunton, Mass, for a variance from Article 3, Section 27.9 and 27.13A to create a 7-lot subdivision to construct 7 single-family homes in an R1C zone. They are located at plots 80, 79, and 7A Plain Street. So that case has been withdrawn and will not be heard tonight. Is there anyone else that wants to withdraw prior to the start of the meeting?
Mr. Chairman?
Yes.
Well, Philip Nesreller, I sent in a letter to the building inspector, albeit later in the day, to request the withdrawal of Adeline LaRoque.
So that one will not be heard tonight then?
Correct.
All right, petition number 2014, the petition of Adeline LaRoque, 76 South Street, Brockton, Mass, for a variance from section 2726, 27.9 to construct a 2-family residence on the site in an R2 zone located at 76 South Street. That petition has been withdrawn and it will not be heard this evening. Are there any other withdrawals prior to the start of the hearing? Seeing none, the way we're going to run the meeting tonight, our normal operation is I will read the petition. The petitioner will then present the case to the board. Following the presentation of the petitioner, I will ask the board members if they have any questions relative to what the petitioner has just presented to the board. Following that, I will then open it up to those that want to speak in favor of the petition. I will read any emails that may have come in regarding that. I will then close that portion and open it up to anyone who wants to speak in opposition. Again, if there are any emails, I'll read those. I will then close that portion and open it up to any elected official that may want to speak on the issue. Following that, I will close the public hearing and I will open deliberations for the board members. On a vote, on a 5-person vote meeting, with 5 members, in order for petition to pass, if there are 5 affirmative votes and no negative, the petition will be granted. If there are 4 affirmative and 1 negative, the petition will be granted. If the vote is 3 in favor, 2 against, it will be denied. So a petition needs a minimum of 4 affirmative votes in order to pass. After the board has deliberated among themselves, I will call for a roll call vote. At that point, the clerk will call the roll and a vote will be taken for the yeas and nays. At the end, I will announce the result of the vote. So we will get our result on the hearing immediately after the hearing before we move on to the next case. Tonight we've got a lot of paperwork here. Okay, the first case this evening is 2107, the petition of Mike Wells and Anna Goncalves, 19 Battle Street, Brockton, Mass, for a variance to convert a 2-family into a 3-family home in an R2 zone located at 19 Battle Street. Is the petitioner ready?
Yes, I am. Good evening, everyone.
I cannot hear you.
You cannot hear me?
I'm going to have to speak louder or closer.
Can you hear me better now?
That's much better.
Great. Good evening, everyone. So I'm coming before the board today because we have a 2-family and we're trying to convert it into a 3-family. We have plenty of space to do that. We have plenty of parking, and we're trying to elevate the left side of the house, part of the roof, left side, and a small piece for a stairway on the right side of the house. Again, we have a few 3 families in the area. My neighbor next door is a 3-family. And we would like to just add another unit to the property.
Do you know what section of the ordinance you are looking for relief from?
I'm sorry, I can't hear you.
Do you know what section of the ordinance you're asking for relief from?
That I do not know.
Okay. Is that the end of your presentation?
That is correct.
Okay, any questions from the board members? And before I get into the board members, let me just reiterate, this is a variance and the petitioner needs to demonstrate a hardship. What is the hardship or the uniqueness about this property that requires action by this board?
Are you guys on yet? You're on.
Can you hear me, ma'am?
I'm sorry, yeah. What was the question?
You're asking for a variance,
Correct.
which means that you have to show a hardship to this board. What is unique about your problem relative to this location that's different from other people's problems in those areas?
The only thing, I mean, I'm just adding a unit to the property. It's not unique to my neighbor next door is a 3-family. There is nothing unique about it.
On the second means of egress out of the top floor, are you planning on putting an exterior stairway in?
Not an exterior, it's going to be inside, on the inside. So we have a stairway on the entrance. So we're adding another one on the inside. So there'll be two stairways. There'll be one on the back, which we already have right now, and we're adding another one to the front. So we'll have a front entrance and a back entrance.
I notice on the plan you have not shown any parking or any driveway. Where is the driveway on this plan?
So the driveway is to the right side of the house, and the parking is on the back.
Okay, thank you. Any questions from the board?
Is John on here yet?
Now I'm going to close that portion of the hearing, open it up for public discussion. Is there anyone here that wants to speak in favor?
Sucks.
Yes, hi, I would like to speak in favor.
Please identify yourself.
Hi, my name is Delilah Gonsalves, and I used to live on the property of 19 Battles, and I can confirm that there's plenty of space for an addition of a third unit. There's more than enough parking with a whole full driveway that fits more than 4 cars and an entire yard that is cemented for additional parking.
Okay, thank you. Is there anyone else that wants to speak in favor? Now we're going to close that portion of the hearing. Is there anyone who wants to speak in opposition? Now we're going to close that portion of the hearing. Is there any public official that wants to speak on this matter? Seeing none, I'm going to close that portion of the hearing. I'm now going to open it up for deliberations from the board. Board members.
Mr. Chairman, Bob Pelagi, I had some similar concerns. The applicant doesn't recite in the application what sections of the ordinance that he or she is looking relief from. There is no lot area on the mortgage plot plan. There's no proposed parking. And because they're so close to the left-hand side, it would have been nice to spot or show the abutting house on the left-hand side. Those are the concerns I have.
And the plan only shows 6 feet of clearance on the west side or the left side of the house.
Right, but we don't know if there's a house on that left side. You don't know if there's a house right up against the lot line. All those houses predated zoning when they were built.
And it is required 10,000 square feet for lot size. And this is a mortgage inspection plan. I'm surprised there isn't a site plan that's drawn for this.
Yep, that's a mortgage plot plan.
Yep. Okay, any other comments from the board?
The houses are not close at all.
Ma'am, I'm sorry, I have to close that portion of the hearing. This is strictly just for the board right now.
Oh, okay, I'm sorry.
No, that's not a problem. Any other comments from board members?
The Steve here, the petitioner did not show sufficient hardship, and also I have concerns that the plans are insufficient.
Oh, I'll entertain a motion.
Were my comments heard?
Steve?
Yes. Were my
Yes, we
comments
heard.
heard?
Yes, we heard.
Thank you.
Yep.
Thank you.
I'll entertain a motion if somebody wants to make a motion.
Move to grant with a expectation that it will be declined.
I'll second.
Motion's been made and seconded to grant. All the clerk, please call the roll.
Mr. Lanus,
No.
Mr. Bernard,
No.
Mr. Pelagi,
No.
Chief Williams,
No.
Chairman Galligan.
No.
Mr. Chair, that's a 0 in the affirmative, 5 in the negative.
Okay, the vote is no votes in favor, 5 in the negative. The petition fails. Thank you.
Thank you.
It's got to be done ahead of time.
It's the internet. He can't get through to the internet.
The next petition, 2108, the petition of Valentino Gomes, 16 Battle Street, Brockton, Mass, for a variance from Article 3, Section 27-9 to rebuild a fire-damaged home which will include a fire escape for additional living and sleeping area in the basement in an R2 zone located at 14 Battle Street.
Excuse me.
Jake, you got this one?
Yes, I do, Mr. Chairman. I'm ready when you are.
Yeah, we're ready.
Okay. Evening, Mr. Chairman, through you, the members of the board. This case, this house and lot has been before the board, I think since 2012 and 13. Several petitions have been allowed and several have been, not several, but a couple have been denied. Historically, to help out the board, it was approved a couple of years ago for a 4-bedroom place. The original house was burnt down. Attorney John McCluskey had that. He then turned that over to me for, he had some, I think his son died, he turned it over to me back then. And I have taken it ever since. The dilemma, to get cut right to the chase, because I know there's a big agenda tonight, the most recent denial was because of a couple of things. I think the most serious of which was the petitioner went, instead of accepting a 4-bedroom situation, went to a 5-bedroom situation, which 3 of which were in the basement, basically below grade. It had concerns by, I think, the whole board because it ended up a 0-5 situation. I went back through the planning board this past year with new plans. I hope the engineer, John Spinks, on this project, I've been on with him all day, is on the Zoom here. I'm told that maybe the internet, because of the Zoom and the weather, he may not be getting through, but I will cover whatever I can for him. He was going to explain that whole fire egress situation, but I think I'm familiar with it enough to be able to represent that to the board. The other reason was that there was no, apparently I was very surprised, there was no site plan with the situation. I think you have before you the original, which was done originally in December of 2010. It was revised in December of 2017, and the present one, which was by Bruce Malcolm in 2020 in November. I can tell you that Bruce came up from Florida. He is no longer in business. I actually sold his business to Hancock Surveyors. But in any event, the plot plan or site plan, basically the same. It's a rear lot. It's where the original house was that burnt down. It's been to court for other reasons, and that is because one of the neighbors appealed one of the allowances because of the roof situation. That was resolved in court. The neighbor is now a friend, if you will, with my client, who's here with me, as you can see. And they have redesigned the house, the peak of the roof, to be basically one that does not exceed what originally was the roof line. The big problem, again, as I said, is that there is 3 bedrooms in the basement floor. They're all spacious. They have, and I did file with the board, actual system that has the egress from all three of those bedrooms. You can see it on the plan. It indicates all three bedrooms have an egress out by this what is a more modern escape situation, if you will. And I've used that word judiciously. It's called egress window well cover. I think you all have color pictures of it. But I am told, and I don't know if John can get on he all day said he was standing by to do the explanation. It does not alter the foundation. It is flush with the foundation. It has been, if you will, approved in many, many states in the US. And John tells me, John Spinks, the engineer, that in many, many cities and towns in Massachusetts, including Brockton. I'm unfamiliar with that, what he said. The questions that you would have had, Valentino Gomes himself has lived here in the city, just so you know who he is. It's important. He's lived in the property that's out front, the multifamily that he owns. He lives there with his brother and his family, and he and his family. The reason they've been trying to get the new house is a very specific reason, that they want to move out of that house after 30 plus years in that house and move into this new house on a build. And I think you have, 10 floor plans, roof plans, and other things, which I think are before you, that indicate what it looks like, where the bedrooms are, and where the egresses are. They have indicated, and I think this is the important situation, the reason they went from 4 bedrooms to 5 bedrooms is because Valentino's brother, who lives in the multifamily with him, has his wife and a son. Valentino himself has a wife and children that move in there, and including his mother-in-law, which has lived with him for all this time in the multifamily. They need 5 bedrooms because of gender and because of, again, the marital situation of at least 2 of them, he and his brother. You show that Valentino owns the property to the west of this, that huge part that he turned into a cornfield, but I think we have approval to do something there, but Valentino has done nothing about that. It's it's an R2 zone, which is multifamily, and I think, as the previous petitioner indicated, there are quite a few multifamilies in the area. But the real crux of the situation came down to us showing Bruce Malcolm's floor plan, not floor plan, but site plan, in case the egress back there, plenty of parking spaces. There were conditions on one of the grantings for a single family house there, in the last couple of years, where they would put up plantings and fences and all the other things. The neighbor is thrilled with it. They are this day the only objector. And again, that case was dismissed in our favor. Bruce Malcolm he came up from Florida, redid the site plan on November 17th, 2020, and it exists as you see it on that plan that I refiled. I can answer a number of questions. We obviously need, on the right side, the sideline situation is very close, 4 to 6 inches, 4 to 6 feet, excuse. But again, Valentino owns that property to the right. There's no rear situation. Frontage to come up to present zoning and stuff is existing. I think the hardship chief and Mr. Chairman and members of the board is clearly that it was an existing structure. It has been approved before for a 4-bedroom. The question now is it approved could it be approved for a 5-bedroom with the basement situation, with egresses. And I can tell you that the plan you have that was approved has a squaring off of what was the kitchen area that was all rotted out, so we could square off the foundation. And your own city inspectors and stuff came, realized that it was really rotted and not safe. And so I think that's why the previous board allowed that foundation, which is not a big deal, but to square off that house lot. The height situation is well within the R2 zone situation. And again, the neighbor, that was his major complaint, and that has been resolved. Valentino has, again, been here in that house, the family house, for over 30 years. He's lived in Brockton since 1979 with his family. And I think that it's about time he's allowed to spend the money to make this thing happen. Again, the hardship, Mr. Chairman, is the pre-existing structure that burnt down. Foundation is basically the same, but again, this board allowed him to square it off, that small square footage. And I think it's time to move on in that situation. I'd be happy to answer. And I might add just one thing back on the 4-bedroom situation. Councilors Moisey Rodriguez and Shirley Yazak, who I believe is checked in tonight, they were in favor of it. And Mr. Valentino, who is here with me, has indicated to me that Tina Cardoza recently has said she has no problem with it. So that's basically the presentation. I'd be glad to answer any questions, myself or Valentino. And I don't know through Mr. Plouffe whether or not John Spinks, the engineer in this project, has been able to get through on Zoom.
Any questions from the board?
Just for clarity, Mr. Chairman, it is going to be a one-family?
Single family.
Single family, yeah.
His family, Mr. Valentino himself, and his brother are going to move in there, who now presently occupy the multifamily that they've been in for years and years.
Why is it that you are still supplying us with these Bilco escape units from the cellar, when the plans that I have in front of me now show that the basement window sills are at least 8 inches above grade level? What's that all about?
I wish I could answer that question. I think you're looking at Mr. Spinks's engineering. Maybe A0.
I'm looking at A6.
A6. I have A6 before me.
On the lower right-hand corner of the building.
Lower right-handing of the building, yes.
See where it says 8 inches finished grade?
Mm,
See, it says 10-inch concrete wall. Then above that, it says finished grade. Then it shows 8 inches. That's the sill height above the finished grade. You see that?
I do not yet finish. I see French drain bedroom, where the bedroom is.
Yes, French drain. Just follow that right up.
Okay, I see. Okay, finished grade 8 inches. Yes.
Yes, okay. So my question is, one of the big hangups we had on this and the last time we were here was all the cellar windows were going to be below grade. And the thought was to put these plastic covers over these windows so people could escape from the cellar in case of a fire. It appears now in this plan that all the windows are above grade for the cellar. What brought that about?
I can't answer that. Valentino, do you know?
That's because
Speak up.
that's because they have concern there was like somebody will fall down on a hole, but now it's flat with the ground, so it's no danger for people walking to fall on in a hole.
Okay,
Do you
I got it.
understand?
It's just that
Okay.
all this has to be by code, the distance from the window to the floor of the basement, so somebody can climb out that window. That's all by building code, which isn't for us. But I'm just curious that that was such a big hangup last time, and this time the windows are all above grade. The other
Yeah,
concern that I have on this plan, the plan that's submitted to us is a plan that was given to us in 2020, 11 years ago. If you look at the plan, the site plan for the building, it doesn't agree at all with the plans for the house. It's off by 6.5 feet.
You mean the plans by Mr. Malcolm?
That's correct.
I'm not
So the
sure what
size of the
you,
foundation is 6.5 feet off from what the plans are for the building. Also, the plans that Mr. Malcolm has given us show no porch, no cellar entrance, no nothing on the left side, which is the driveway side. So right now, we've got a new porch that extends 6.5 feet out into the driveway. And that's not on the site plan. So I have no idea how much room we have between this porch and the side yard.
without getting, I can see what you're talking about, but I can tell you that he was just doing the site plan as it existed then and now.
Whether it existed or not, it's what's presented to us as a board tonight. And my
I
concern is,
understand.
we're voting on something that doesn't agree with one another. We got a foundation that's 6.5 feet different from the house that's proposed.
Well, no, the deck situation, I think, if it came in towards the pavement situation on the easement going in there, isn't even close, I don't think, Chief, Mr. Chairman, to affect, even if there was a deck here. But again, the board could eliminate the deck as far as we're concerned.
Yeah, well, all right. So the other concern that I have is, in the past, when this has been before us, we had people here from Division Street that were very concerned about what was going to be happening in the backyard. And if I remember right, we had talked about putting trees along the back.
Right.
And some kind of a fence along the back.
Correct.
And they delineated where the parking was going to be, where the green space was going to be. And I think in the last time out there, we were very specific about where that parking was going to go. This plan doesn't show that at all. The other thing relative to parking is number 16 and number 18, the 3-decker out front. It shows no parking for that whatsoever. And the other interesting thing that I don't think the city is going to allow is the sewer connection coming from this proposed new house right through the 3-decker. I would think the city's going to require that to come down the driveway.
The sewer's gonna be separate from that. It's not gonna go to the 3-decker.
It's not going through the 3-decker.
No.
It's coming off the street.
Yeah.
My client is indicating, Mr. Chairman, that it's coming off of the street. Apparently, we have made arrangements on that
Yeah,
situation.
it's gonna be separate.
And so it's not coming through the 3-decker, which it originally was, as I believe, and I think.
Yeah, you know, years ago, a lot of them did that. And I'm sure this house that burned down, that's probably the sewer line that went to that house. I guess what I'm trying to say here is, here's a plan that's 21 years old. And we're trying to squeeze this new house onto this old plan. And I'm just very concerned that what I'm potentially voting on here tonight is not what is on the plan that's in front of me.
Well, I
guess
just
that's
think,
all I
Mr.
need to
Chairman,
add.
my comment would be, it's the existing foundation, except for that little expansion that the board allowed some time ago. It's going to be a single-family house, and the reasoning for it is because the two families that have lived in the multifamily, brothers and their families, are going to move into the new house, and that the situation is necessity because of gender and the age and the marital situation. All the stuff that was conditioned before Mr. Valentino was agreed to do, the fence, the this and that, there's obviously plenty of space for numerous cars back there. And presently, as I'm sure the board remembers before, those members that remember, the parking for the multifamily is just beyond the multifamily situation, goes into where the area that Mr. Valentino owns to the west, which is twice the size of this lot. So, I understand what you're saying, Mr. Chairman, but again, I don't see a problem with it. It is a
I just wish
hardship.
we had been a little bit more definitive on this. I feel as though what happened here was an old plan was given to the board and new plans were trying to superimpose over this, and they don't fit. They just, you gotta ask for relief from side yard setback, which isn't there. We haven't even discussed the driveway situation going out to Battle Street. It looks like it's an 8-foot right of way.
That's
So
correct.
I think what that says is the whole property line or access is 10 feet. Is that true?
Is what?
10 feet with an 8-foot right of way. So this house in back only has access to Battle Street over 8 feet in width.
But that was the existing, again, the existing, pre-existing lot situation, which had access to that rear house before the fire.
So has that changed?
No? Valentino, has that changed?
What, the driveway?
Okay, I'm gonna just, I'm done asking questions. Are there any other questions from the board before we move on? Is the board all set? All right, I'm gonna close that portion of the hearing. Is there anyone here that wants to speak in favor? Mr. Clerk, we got anybody?
I do not see anyone raising their hand to be in favor.
Okay, I'm gonna close that portion of the hearing. Is there anyone here who wants to speak in opposition?
Mr. Chair, I don't see anyone raising their hand in opposition.
Okay, I'm gonna close that portion of the hearing. Is there any public official who wants to be heard on the issue?
Mr. Chair, I see no public officials online raising their hand.
Okay, I'm gonna close that portion of the hearing. I'm gonna open it up now for discussion from the board. Board members.
The chief is quite familiar with this situation. I did serve on the board for many of the past hearings and recall that many of these issues that he brought up, I would concur that therein lies some problems for the current presentation. So I too have those several concerns that the chief has.
Mr. Chairman,
Yes.
whether these basement window exits comply with code or not, I don't like them. I think it's a dangerous situation in case of a fire. You're asking basically two families plus Mr. Gomes' mother-in-law to climb out of a basement window. I'm just not comfortable with that. I think Mr. Gomes needs to kind of revamp his plan so that if he wants 2 floors of living space, the first floor needs to exit right out at grade level. I don't think it's safe to have those basement windows the way they are. Thank you.
Thank you. Any other board members? I'll entertain a motion.
I'll make a motion to approve in hopes it does not prevail.
I'll second it.
Motion has been made and seconded to grant. Mr. Clerk, please call the roll.
Mr. Lanus,
No.
Mr. Bernard, Mr. Bernard,
No.
Mr. Pelagi,
No.
Chief Williams,
No.
Chairman Galligan.
No.
Mr. Chair, that's zero in the affirmative, 5 in the negative.
Okay, the vote is no votes in the affirmative, 5 in the negative. The variance is not granted, fails.
Thank you, Mr. Chairman.
Thank you.
like the fire escapes, even though they're legal.
Okay, what I'm gonna do, I'm gonna eliminate the.
The next petition, 2109, the petition of Robert Jordan, care of 1325 Belmont Street, Brockton, Mass., where petitioner seeks a Massachusetts General Law, Chapter 40A, Section 6 finding by the board that the pre-existing non-conforming use may be altered as the proposed use shall not be substantially more detrimental than the existing non-conforming use to the neighborhood in an R1C zone located at 555 Plain Street.
Thank you, Mr. Chairman. Good evening, Attorney John McCluskey, Mr. Chairman, members of the board, Mr. Plouffe. Thank you for hearing us this way this evening. It was a little tricky getting on, but it seems to be working well. I represent Robert Jordan, Jordan Brothers Seafood, and we were before this very board, for the most part, all of the same members in October 2020, seeking a variance to allow for the use of the Jordan Brothers seafood operation at 555 Plain Street. We're before you tonight on a slightly different angle and under a different section of Chapter 40A. And I'll explain a little bit procedurally how we happen to get back before you. Back in October, I presented the board a petition for a variance. And in fact, it was based upon the facts that are identical to the facts that I'm presenting to you tonight. What happens is that the Jordan brothers have a small family-operated seafood operation. It consists of Bob Jordan, his daughter, a couple of sons, and some employees who live in the Brockton area. Everybody's living right around here. And they've been in Brockton for 11 years over at the old Kelleher property, Sergeant's Way, and it really doesn't fit for their desired use. It's an industrial type place, auto body shops all over the place. It's very difficult to operate there. So they found the property at 555 Plain Street, which is, although in a residential zone, it's been commercially used since what I can determine back to 1933, when it was the French Cleaners and Dryers, Inc. From there, it went on to a cleaning plant for many, many years. Was a garage where I believe the Varecas were repairing automobiles, perhaps motorcycles back in the day. It was a woodworking plant. At one point, there was a church in there, quite a few people coming and going on the weekends. Presently, the property is used by Charlie Hunter, who is a plumber in the Brockton area. He operates in the building and stores things inside and outside the building. There's quite a few trucks and some debris around the property. The Jordan brothers propose to transfer their business over to 555 Plain Street, and this is what they do. They have 4 or 5 pickup trucks with coolers on the back, F-350s, and in fact, a couple of the trucks are very small delivery vans. And what they do is that one of the trucks goes to Boston every morning to the fish pier, to the auction, and buys high quality pre-cut fish. So what they're buying is not a whole fish, they're buying a slab of fish. They bring it back to the property, offload it from their pickup truck, and bring it indoors. Whereupon, for the next few hours, the employees will repackage, cut the fish, which is a clean fillet to the start. There's no bones, there's no scales, there's no waste. They'll cut the fish and repackage it. And then off it goes to a couple of different places. One, restaurants where they deliver the fresh fish, and the chef just needs to open the package, cook the fish. It's already pre-cut, It's already in perfect shape. They also go to farmers markets. You may have seen some of the farmers markets. I know of one down in Hingham where I see Bobby Jordan in his very, very small delivery truck, and he sets up and sells fresh fish for a few hours a day. The operation is almost entirely indoors. The only outdoor activity is when the truck pulls up, backs up. There's no beeping, no special noise with the truck. It's just a regular pickup truck with a cooler on it. Backs up to the door. They offload the fish. The truck gets turned off, and when the fish is cut, sometimes that day the fish will go back on the truck and be out for delivery. They're gone from the facility, at least the workers in part, and there's probably at best 5 or 6 people that work there. Bobby Jordan gets there early in the morning, 5 or 6 in the morning, begins to take shape of what's going to happen inside, along with his daughter, and they get the place ready for the day indoors. There's no noise, and then on certain days in particular, I think on Saturday mornings, off they go to the farmers markets. So there's really very, very little activity that happens at the facility, especially outdoors, but the real workings of it is all indoors. Now, one of the questions that came up in the October 2020 hearing was trash. I've been in touch with the Brockton Board of Health as far as the particular way of handling this trash. They generate about 1 household barrel of trash a week. It consists mostly of rubber gloves, paper towels, once in a while, a little debris from a piece of fish that perhaps it has a piece of fat on it or something that goes into the trash. The trash is kept in the cooler, which is at 38 or 40 degrees, something like that. And it stays there until it's taken outside and picked up twice a week by a trash contractor that they have a relationship with. So there's no trash that's stored outside, and the Board of Health has indicated a clear willingness to work with the exceptions of not having to use a dumpster, although we do show a dumpster on the map. It probably would not be used, and it certainly would not be used for any debris that's generated inside. Now, so basically, the operation is no different than what is going on there today, probably a lot different than what has gone on there in past years, because especially for the auto body that went on for many years, that was required cars to be stored outside. There were delivery trucks coming and going, people dropping off with flatbeds, vehicles. The cleaning facility was a liquid facility that washed clothes and then later got into dry cleaning. That required a lot of delivery trucks coming and going. Charlie Hunter keeps his plumbing equipment there, and he comes and goes on a regular basis, and he's a very busy plumber throughout this South Shore area. So although it is quite a bit different than what's gone on there in the past, it's hardly comparable to any kind of activity that you may have seen there in the past. It is in a residential zone, but as the board found back in October, it's of unusual shape, size, and characteristic, and the board actually made a specific finding that the variance will not be detrimental to the existing neighborhood or adjacent properties and will not negatively impact traffic on the surrounding streets. After the decision in October of 2020, 3 of the neighbors appealed, stating that they were harmed, although they haven't been able to prove it yet or haven't shown any harm, that this is going to cause an increase in traffic. There's going to be debris and smell, foul odors. That just doesn't happen. In fact, if you go down to where they presently are, there's very little activity on their part. There is no odor. There's nothing no trash storage outdoors, absolutely nothing like that. So we went to court because the plaintiffs appealed the case. They appealed the issuance of the zoning. We were assigned Chief Justice Gordon Piper, who was the land court chief judge, as the trial judge. And we had in November a case management conference. At that case management conference, Judge Piper listened to each side, and then he said, this is really like a Section 6 case. Why don't you think about going back before the board on a Section 6 case? And what is Section 6? Well, Mass General Law, Chapter 48, Section 6, requires that if you have a pre-existing non-conforming use, in order to have a new use there, the board must find that the new use shall not be substantially more detrimental than the existing non-conforming use to the neighborhood. The board also needs to find that no such alteration shall be permitted, unless there's a finding, and it shall not be substantially more detrimental. In fact, the board did find those specific findings in October 2020, but that was in the variance case. So what I'm asking you tonight is to make those same findings that the board found in October 2020 and make them under Mass General Law, Chapter 48, Section 6. 48, Section 6 does not require the finding of a hardship. It only requires that the board find that it shall not be a substantially more detrimental use than the existing non-conforming use. So Charlie Hunter's existing non-conforming use is a commercial use in a residential neighborhood. This property looks like a commercial property. It's been that way for years. And interestingly, all of the plaintiffs in this case bought their homes knowing that they were going to be near, in proximity to this commercial property. And now they appear to be trying to change that. On Friday, I received a motion by the plaintiffs trying to prevent us from coming before the board, which the court on its own quickly put the kibosh on, because clearly we have the right to come before the board tonight and ask for a Section 6 finding. And I basically respectfully request that you find almost the same things. In my application, I also said that we would be happy to stipulate to the conditions that the board found in October 2020, hours of operation, no Sunday hours, no retail sales. This is strictly a wholesale project. Nobody comes to buy fish on the property. All waste to remain inside refrigerated with no fish products to be disposed of in any outside dumpster. Any dumpster shall be maintained by the city dumpster regulations. Only pre-cut operations as presented will be allowed with no full fish processing. And they haven't done a full fish processing ever. The front area of the building, they're going to spruce that up. They're going to clean it up, remove some blacktop. Excuse me. All security lighting will not spill over the property, will be on the immediate property. We've tried to talk to the neighbors about putting up berms and fencing. Well, the family wants to put up fencing, wants to put up nice shrubbery, wants this place to look beautiful because this is their family-run operation. There'll be no noise, offensive noise, or any noise coming from the refrigeration, and no further expansion on the site without further permission. So with that, I would respectfully request that the board basically do the same thing that it did back in October, but do it under Mass General Law, Chapter 48, Section 6. And you know what? If the plaintiffs are going to continue to fight about it, we can resolve those issues in court. I would respectfully request that you let us go forward and not be persuaded by the plaintiffs to deny what basically you've already approved back in October. And I thank you for that. And I hope that the procedural matters of coming before the board again are clear, that we have the right to do that. and that you'd see to it to make essentially the same findings and conditions. Thank you.
Thank you. Any board members have any questions on what we just heard?
I had one question, for the attorney, is the appellant party, is that the party that's to the left of the subject property? Is that who's appealing? I'm not quite sure who is bringing the appeal.
You're not quite sure what, Bob?
Who's bringing the appeal?
Oh, the appeal was brought by Mr. Rodriguez, who's not a direct abutter. He's on 18 Cushing. It's being brought by Mr. Ambandular at 32 Cushing. Those are obviously a different street. They're in the back. Mr. Ambandular is significantly away from the existing building. And then there's another gentleman who is back on Cushing. Incidentally, Ginny Jepson, who is very active in development and knows what's going on in the area, she spoke at the October meeting for quite a bit of time in favor of this project, and she's immediately across the street on Plain Street.
All right, thank you.
Any other questions from any board members? Now I'm going to open up for public discussion. Is there anyone here that wants to speak in favor?
I do not see any hands raised, Mr. Chair.
I'm going to close that portion of the hearing. Is there anyone here that wants to speak in opposition?
Mr. Chair, we did receive a large, long letter from the appellant, the private case, and the appellant's attorney is on, Mr. Preston, Preston Chilton, is it?
Preston Clinton.
There you are. Sorry about that, Mr. Preston Clinton. Go ahead.
Thank you.
For the record, Mr. Chairman, they did not send me that letter.
Noted. Mr. Clinton, floor is yours.
Thank you. I would ask the board to not make the same finding because where the petitioner, Mr. Jordan, has brought this under a different section of the law. And I would ask the board to not make the same finding that they made before based on some additional some facts and also different sections of that law, section 6. One is that, at least as of this morning, 555 is very neat and tidy under the current non-conforming use. I saw one truck, very quiet, as opposed to the petitioner's location of his current operation, which has coolers stacked up in front of the building, crates stacked against the fence, barbed wire fence around the building, trucks and vans parked in the front, and also the use as a garage, which began sometime in the 1930s, and then that was the use at the time of the zoning laws, is substantially the petitioner's use, proposed non-conforming use is very, very different, and there's no reasonable connection that you can draw to that garage. There was a garage, and then there was a variance granted by the board in 1984 for the cabinet carpentry shop. Section 6 relief is not available when the non-conforming use derives as the result of a variance, which the board granted in 1984. But to the question of whether the proposed use is substantially more detrimental to the neighborhood, it certainly is. The zoning classifications of the prior uses were all within like a C1 or C2 commercial use. The proposed use, the petitioner's proposed use, is under one of the industrial zoning classifications for manufacturing plant, where it's packaging and processing of food, or under the I1 industrial classification or the I2 industrial classification. So essentially, the petitioner is asking you to make the same ruling, but they're asking you to take an industrial use and put it into a residential neighborhood. And that is far exceeding the prior non-conforming uses of the cabinet shop, the church, and the auto garage. The purpose of this chapter, the Section 6 protection, is to protect that original non-conforming use that existed when the zoning laws came in, not to offer the same protection to a different non-conforming use simply because they're both commercial uses. Although it's not listed, also there will be a substantial changes to the building itself, not just the use that will be detrimental to the neighborhood, including the addition of some of the industrial freezing equipment that would be necessary to keep the trash cool inside and the fish. Although there are some mitigating suggestions, I mean, the nature of the business is that there's going to be waste and odor emitted from the property. Additionally, all the prior non-conforming uses were all dry operations. We're not dealing with like food and not food processing and not food packaging. And so for these, also we don't have any, it's the petitioner's burden to demonstrate that there was a lawful use of the property at the time the zoning laws came in, and then that lawful use was permitted to continue. We haven't seen that. And the frequency of the trucks in 1930 for a motorcycle garage, and the frequency of the trucks in activity in 1957, and the activity, the plumbing activity, I can speak to. The frequency of the cleaning activity, we haven't seen any evidence of any of the frequency of any of those activities. So to make the claim that the petitioner's proposed use will actually be less activity is unsubstantiated. There's also the issue that hasn't been addressed of, what could potentially happen if power is out and the freezers aren't working. It's all dependent on industrial freezing equipment and installation thereof, which would not only change the use, but also change the use of the property, but also alter the building in a way that would be a different non-conforming use from an auto garage. So again, it's not deriving from the original use. I did submit a letter, and thank you for the opportunity to sort of summarize some of the points that I had submitted in the letter. So I would ask the board to please deny the petitioner's the petition of Mr. Jordan. Thank you.
I do believe we lost the chair for a few seconds. We'll see if we can reestablish connection with him.
You back? Can you hear me?
Yes.
Yes.
I lost everything here for about 30 seconds.
Mr. Chairman, I think maybe you missed that I was just concluding and thanking the board for the opportunity. So, and asking the board to deny the petition. I'm not sure how much you missed. Thank you.
Is there anyone else that wants to speak in opposition?
Mr. Chair, I don't see any hands raised.
Mr. Chairman, may I just respond very quickly, 15 seconds?
I'll give you 10 seconds.
All right. Not quite sure what ordinance Mr. Clinton is looking at, but he fashions this use, the proposed use, as industrial. I don't know what he's reading. He's got to be reading from some other town or city. Commercial uses are catering, bakery, frozen food lockers are commercial use. So the Jordan Brothers proposed use is not industrial, and I don't know where he gets that from.
Okay, thank you very much. Is there anyone else that wants to speak in opposition?
None seen, Mr. Chair.
Is there any, I'm going to close that portion of the hearing then. Is there any elected officials that want to be heard on this issue?
Mr. Chair, I do have Mr. Tony Rodriguez holding his hand up. He's in opposition.
Represented by counsel.
All right, I will reopen that portion as a matter of courtesy.
Mr. Rodriguez, you can go ahead.
Hello, can you hear me?
I can hear you.
Good, good. I just wanted to just make a statement on why this proceeding was even granted, knowing that this is in litigation and we're taking this matter up for another vote in granting any type of variance in this property.
Okay, thank you very much. I'm going to close that portion of the hearing. Is there any elected officials that want to be heard on this issue?
I see none, Mr. Chair.
Okay, I'm going to close that portion of the hearing. I'm now going to open it up to discussion from the board. Board members, any comments? I'll start off the discussion. Dealing with this COVID situation has not been the easiest thing to do. However, I have been spending quite a bit of time on this, delving into paper records and looking back on a few things here. First of all, on the application that was given to us dated July 14th of 20, a question was on the application sheet. Has any previous appeal to the Zoning Board of Appeals been made for this property? And the petitioner checked off no, that there had been no other action by the board at this property. I thought that was a little unusual, and I dug into a few things here and found that in 1967, this location was granted an expansion of 12 feet by 30 feet to the building. In 1979, a variance for this property was revoked, and I could not find what that revoking was, but that was in 1979. In 1984, it was before the board for a change of use, and it was granted. And I believe that 1984 one was the sale of cabinets and other related components. That was in 84. And in 1988, there was another hearing before the board requesting an expansion, an addition to the building, and that was denied. So basically, when you look at this building down here, I spent a little time down here looking at this building, and there's no question you can see a front half and a back half. There's two parts to this building. There are 6 Edison meters on the side of the building, which I find kind of unusual. But the square footage of the front building, when you consider the addition on the back is actually 50% of the square footage of the front of the building. Well, in our codes, it specifically says that any building that's non-conforming in an area such as we have right here, it cannot expand more than 50% of the original square footage for the rest of its life. So there was a couple of requests here where they wanted to expand this building, and in one case they were granted an expansion, and then they came back again in 1988 and they were denied. And what has come before us in this last granting that we gave was a further expansion of this building to put a refrigeration unit building on the back of this building. And in retrospect, we had no right to do that. The building cannot grow more than 50% of what it originally was. The prior occupant of that building put the addition on and did create that 50% addition. And now the petitioner that's before us wants to put a further addition on the back of that building. And quite frankly, that's not allowed. So unfortunately, in my case, I will say a couple of things have slipped by me. That was one of them, that the building cannot be expanded. The other thing that, you know, a lot of things that we do on zoning, we try to be as friendly as we can, and we look at every situation uniquely. This building is a commercial building. It's going to be there for the foreseeable future unless something happens to it. But something is going to go in that building at some point, obviously. Whether this is the right thing to go in there remains to be seen. But the point I want to make is this building cannot grow any bigger than what it is. It is maxed out. The proposed occupancy of this building, when you read our zoning very carefully, specifically says that if a non-conforming use of this building can be put in a conforming use area, then we have to deny that use of the non-conforming use in this non-conforming building. In other words, the fish processing that we're talking about here belongs in an industrial zone, according to our zoning. Sometimes when you look at a hardship, which we didn't hear tonight again, there has to be something that is going to trigger allowing an industrial use to go into this residential neighborhood. And quite frankly, if you read our zoning very carefully, it does specifically say that this type of occupancy belongs in an industrial area, not in a residential. So I think we've got to be very cognizant of the fact that if we are going to reaffirm that this is not going to be detrimental to the neighborhood, one of the things I personally will be looking at is the requested expansion of the building, and the building cannot be expanded. It is maxed out where it is right now. And when you look at non-conforming uses, I dug into what they call the powers test, modification of non-conforming uses. Powers versus the building inspector of Barnstable. And it's kind of funny that this thing is in italics, that this should be required reading for everybody on the subject. And they call what they call 3 prongs, for the lack of a better word, on 3 tests to see whether something fits in a situation like we have right here. And the first one is whether the use reflects the nature and purpose of the use prevailing when the zoning bylaw took effect. And it's pretty obvious from all the conversations we've had, a whole myriad of different occupancies have been in this building since it was built. So if that one doesn't work, then it constitutes a change in use. Secondly, whether there is a difference in the quality of character as well as the degree of use. What we're hearing is the potential use of this could be less than what was in there previously, but that has to be considered for what was in there before as opposed to what's potentially going in there right now. And the third prong is whether the current use is different in kind in its effect on the neighborhood. Well, obviously, if we had a cleaning plant, we had a woodworking plant, we had a motorcycle plant, we had a car repair facility, we had a church, and now a potential wholesale fish operation going in there. This is certainly different than what effect other occupancies have had in that neighborhood. So I'm just explaining how I am looking at this. This is, in my opinion, a family-run business that appears to be a very well-run business. But I do have to look at the rules and regulations, the ordinances, and number one, I personally made a mistake when I voted to allow this building to be expanded, to put an addition on the back. We can't do that. The law says specifically in the Brockton ordinances, we cannot do that. And whether or not this is going to be more detrimental to the neighborhood, I would say with the addition on the back, it certainly would be more detrimental to the neighborhood. So I think whatever happens here, we're going to have to rethink where we're going here. I don't know legally what can happen with the variance. I don't know how we're going to vote tonight, but it'll be interesting that if the vote is that we find that it is more injurious to the neighborhood, how that will affect the case relative to the variance allowing this non-conforming use in a residential area. But it isn't something that should be taken lightly, is what I'm saying. And the more I dug into 48, I dug into our, I read very deeply into our zoning ordinances, and I did some research in the building department, digging out old variances that were granted, and I was kind of disappointed when I was told that there had been no other variances granted on this building, when in fact there has been a lot of activity here. And the other thing that I kind of didn't pay much attention to, but I did recently when I was there, is the electrical service on the side of the building with 4 meters on it. I don't quite understand whether there's 4 occupancies in there or what. I personally, as one member of this board, I have concerns that I cannot vote for this with that expansion on the back. It is illegal. We cannot do it. We should not have voted to allow that addition to be put on the back. But beyond that, I guess it's up to every board member to determine whether or not the proposed use is going to be more detrimental to the neighborhood. So I think tonight, when we do take our vote, what you're going to be dealing with is a yes vote and a no vote. And if you vote yes, I would take that you feel as though this use of this property will not be more detrimental to the neighborhood. In other words, you're voting for the petitioner. If you vote no, then your answer is going to be that you do feel that this is more detrimental to the neighborhood, and you are voting against the petitioner. That's how the vote will go when we eventually get to the vote. But I just want to express my concerns. I have no ill feelings with these people at all. I think they run a great operation. However, I do have to look out for the neighborhood down there, and there are some very specific things in our zoning that I have to follow to the letter of the law. And specifically, we cannot allow them to put an addition on that building, number one. That's my thoughts, unless anybody else got something to say.
Mr. Chairman, I know I'm not supposed to do this, but we'll
you're
waive
not.
the addition. We'll waive the addition.
Any other board members?
Too much knowledge can sometimes be very dangerous, and but when saying that, however, it prompts that how often do we have an opportunity, Mr. Chairman, to change our minds or are allowed to look back at a case that we've already approved or denied, and in essence, that is what is happening by your further research. You're saying, okay, now that I know what I didn't know, I want to change my vote.
No, I don't think it's quite that way, Steve. I think what I'm saying is I voted to grant that variance with all the stipulations that are there that I thought would protect the neighborhood. And I did that in all good intentions on my part. What I missed here is the fact that the building cannot be enlarged more than 50% of its original size. And I missed that.
Mm-hmm.
So now they have enlarged the building. They came back once before to try to put another addition on, and they were denied because they had already reached that.
Right, I heard that.
Again,
Mm-hmm.
you know? So it is. I think it's. Don't ever remember having an opportunity to step back and say, I wish I did something different. But all I'm saying is, whatever the vote is tonight, the case on the appeal of the variance that we granted will probably still go forward. This is only one piece of the whole pie.
Well, I know that we carefully deliberated, as we do in all cases, back in October, whether or not this petition should be granted. And with the information we had at the time, we granted it. The presentation that was given tonight by council was exactly that which was given back in October. And what I heard as tonight, as what I heard back in October, is that the use would not, the non-conforming use would not be any more non-conforming than the previous use, and therefore, in my from what I hear, I would agree that it deems a granting of the petition. MGL Section 40A, Section 6, and I would make a motion to grant the petition as presented.
Okay, somebody want to second that?
I'll second the motion, but I would remind, or may I amend the motion to include the council's offer not to expand the footprint of the building. That was a suggestion or an offer made by council, and I will
accept that as part of my motion to grant.
That was not part of the presentation. In fact, it was never brought up in the presentation. So can we stipulate that the addition not be added? I guess you could stipulate whatever you want. As if it is our idea rather than it being heard after the fact. If so, I would make a motion to grant with a stipulation that no addition can be added to the building. I don't think that's what we're being asked to vote on tonight. The judge has remanded this back, or the petitioner has expressed a desire to reaffirm that this board agrees that as this case was presented, it does not negatively affect the neighborhood. We can't sit here now and start making changes. We have to vote on what we granted as a variance.
Okay. Okay, I hear you loud and clear, and I would still like to put forward my motion, even though it does not include the hope that what we didn't hear would be added. So my original motion would stand, and I would ask you to call for a second if you so desire.
I'll second.
Okay, motion has been made and seconded. Clerk, please call the roll. A yes vote now, keep this in mind. A yes vote reaffirms our decision that this will not have a negative effect on the neighborhood. A no vote indicates that it will have a negative effect on the neighborhood.
Mr. Lannis,
Yes.
Mr. Bernard,
Yes.
Mr. Pelagi,
Yes.
Chief Williams,
Yes.
Chairman Galligan.
No.
Mr. Chair, that's 4 in the affirmative to 4 in the affirmative, 1 in the negative for the finding.
Okay, the final vote is 4 in the affirmative, 1 in the negative. The
Thank you.
petition is granted.
Thank you, Mr. Chairman, board members. Appreciate it.
Next petition, 21-10, the petition of Eugene Flynn II, 162 Country Club Lane, Brockton, Mass. For a variance from Article 3, Section 27.9 and 27.13A to construct a single-family home on an existing lot in an R1C zone located at plot 49/0 Thatcher Street.
Good evening, Mr. Chairman, members of the board, Mr. Clerk. Just this is Attorney John McCluskey again. Just getting shifting gears here for a second, and bear with me. Okay, this is a petition of Eugene Flynn to sort of a twofold application. This is property at 155 Thatcher Street, which is a 16,609 square foot lot with 100 foot of frontage. Originally, this lot was part of what is 3 lots that exist on the ground now, 3 vacant lots. Then we have the one on Thatcher Street, and then it moved out into in your plans that I've submitted to you, lot 4 and what I call the land court A plan. The A plan went back all the way to Oakland Street, and from what I could gather, but it's difficult, getting into City Hall and figuring out what was there back in the day. But I think that at one point there were 3 lots in existence. Then they were merged by this lot 4, which obviously that happened before 1979, and they became 1 lot. The owners of the property at the time went to the Board of Appeals and had the lots divided, lots 5, 6, and 7. That was Nate and Oscar construction. And that, I believe, happened in around 1958. But lots 5, 6, and 7 eventually became land court lots, and they're all shown as separate lots on separate certificates of title. In 1979, the Zoning Board of Appeals in Brockton granted a variance allowing each of them to be a buildable lot. They didn't do anything with them. They didn't build on them. They didn't do anything. And in fact, I think at that time, wish I had a couple minutes just to go through my plans once more, but I think at that time, they hadn't yet split them up into 3 lots. And then because of that, the variance expired. They came back to the Board of Appeals in 1985, and they received another variance. And within that year, the owners of the property divided up the lots and created 3 separate and distinct lots. Also at the time, they were assessed by, and still are, by the city of Brockton for a betterment for sewer, I believe water and sewer. So again, though, in 1985, although nothing really happened and they continued to be not built upon, my feeling is that because they split the lots and recorded 3 different deeds, one of which said, this is for the purpose of distribution of the remaining assets of this property. So the first question I have is, did the 1985 variance lapse? And my position is that it has not. And the reason is that so often building departments look and they say, well, you didn't get a building permit within a year. And I would agree that there was no building permit issued within a year. However, the statute says that you have to act upon, it says if the rights authorized by a variance are not exercised within 1 year of the date of the grant, the right shall lapse. My position is that because they split the lots up and created 3 separate land court plans and lots, that they did exercise their rights under the variance. Also, interestingly enough, the assessor assesses and continues to assess lots 6 and 7 as buildable lots. And this lot, lot 5, for whatever reason, even though it's the largest lot and has the most frontage, is not assessed as a buildable lot. So I'm scratching my head. I couldn't find in the records, not being able to do the research at City Hall, I couldn't find out why that was the case. But in any event, my feeling is that because of the fact that they deeded the lots out and are assessed by the city for the betterments, that in fact the variances did not lapse. There is support of that. I had a lot over in Chestnut Woods Estates that the prior city solicitor agreed with me and gave the building department a letter concluding that even though a lot was not, we didn't ask for a building permit, that the lot the variance did not lapse because they had a sidewalk in front of the property and they had water and sewer available to the property. I think it was stubbed in. Again, interestingly, the lot in the back, I think it's lot 6, got an order of conditions about a year ago, and I'm told that they didn't get a building permit because they didn't pay the fee. So those 3 lots were together. I'll switch gears for the moment then and say the next thing I'm looking at is that we're entitled to a variance under the statute. And basically, if this lot, if it's not going to be allowed to be a buildable lot, then it's orphaned, if you will, because it's separate and apart from the other lots. And it's a good sized lot. I actually drove by the lot a couple weeks ago, and quite frankly, this lot is crying out for some attention. The lot is overgrown. There's debris all over the place. It's unsightly. And I think it would be important for the benefit of the city and the neighborhood to take this lot and to allow it to be, for the 3rd time, a buildable lot. It has 100 foot of frontage, which is significant in that location. It's got 16,609 square feet. The hardship is that it actually has an awkward looking. It's got a driveway on it that leads to the property next door, but the property next door, which was owned in common with the current owner of this property, has its own separate driveway anyway. So I don't think that that driveway is all that important. You can't get adverse possession, by the way, because it's registered land. So that driveway is no longer effective. But I think in general, because of the fact that this lot really, one, it got 2 prior variances. It's excellent size. The house fits on the property well. You've seen the plan. There is some drainage off on the right-hand side, which has been addressed, and we'll have to readdress it with a botanist to make sure and get an order of conditions. But I think that, especially where the order of conditions was granted on the back lot, that the Conservation Commission will do that as well. So I think all of those things taken together, at the very least, if the board does not see that the variance hasn't lapsed, I think that because of the betterment assessment, the unusual shape and size, soil conditions and topography, we've got the drainage basin to the right, and gives us unusual soil conditions. It's of unusual shape and size. I think it fits well within the parameters of 40A section 17. I'm sorry, 40A section 10. And that the hardship is that it really cries out for some attention. This is a hardship on the land at this point. Thank you.
Thank you. Any questions from any of the board members? So just to clarify, in the past, when variances were granted for this location, as those variances ran out, they had to come back for a new variance, correct?
Say that again. It's
in the past, as these variances were granted for this location, as the variances ran out, they had to come back for new variances.
Well, yeah, I'm saying, I at least as to the second variance, I don't think that it necessarily ran out, because what they did after that second variance is that they split the lots up. They deeded one to this guy, one to this guy, and one to this guy. In fact, the assessor considers 2 of them, the smaller ones, interestingly enough, as buildable, and doesn't assess this one as a buildable lot. But I think because of that split and the fact that they're registered land, that gives them the rights under the old variance. It's been a long time. There's no question about that. And the board may feel more comfortable granting a variance, but I still think there's a pretty good argument that that variance did not lapse.
I guess my argument would be that you could create the lots, but because you created the lot doesn't mean it's a buildable lot. So when you get a variance, it's usually for the house that's going to be built on that undersized lot.
It is an undersized lot, and it was in common ownership with the lot next door. But remember, it's a this even could be arguably a grandfathered lot. It's registered land, so they were separate and distinct ownership. I know there's some unusual discussion about registered land and mergers, but I think this might very well fit even under that scenario.
Okay, any questions from the board? No questions from the board? I will close that portion of the hearing. Is there anyone here that wants to speak in favor?
I see none, Mr. Chair.
I'm going to close that portion of the hearing. I will now open it up for opposition. Anybody want to speak in opposition?
Mr. Chair, I see none, but I do have a letter here that I could read into the record.
Is this from Craig McConnell?
Yes, it is.
All right, you want to read it?
Certainly. From Craig McConnell, 144 Thatcher Street, Brockton, Mass. 023202. Dear board members, we are writing you to express our extreme opposition to the petition of Eugene Flynn, construct a single-family home located at Plot 49, on Thatcher Street in Brockton, Mass. Adding another home on too small of a lot that contains a variety of wildlife will be detrimental to me and my neighbors and neighbors behind the proposed building site. The small forest that the lot sits on is a habitat for wild turkeys, woodpeckers, fox, deer, groundhogs, and other birds and wildlife. See photos, second page. And for the record, we have a page of photos. It will also adversely affect homes behind it because of the following. Proposed building sits on an old rocky stream bed. At one time, there was a pond located at number 28 Thatcher Square that was fed by an underground stream that still exists behind my home and my neighbors to the right of me. See map, second page. I know this because I did research after my home flooded numerous times because of the new construction on Jacob Street. Jacob Street water ran down people's backyards and into ours and into our garages and down the steps to our basements. Even with two sump pumps in my basement and more in my yard, the water would become overwhelming. I've had to replace 2 furnaces, 2 hot waters, and 2 washer and dryers, and can only use my basement for storage, as all those occasions I had at least 3.5 feet, yes, feet of water in my basement. When the floods occur, I pump the water out and down into a natural drainage ditch beside my house, which runs underneath the street and directly where the proposed house will be. The water continues down through the woods and ends up flowing into properties located in Oakland Street. I witnessed this firsthand as I wanted to see where the water ended up. To summarize, Thatcher Street does not need another home that will rid the area of the little wildlife we have to enjoy and put at risk a new homeowner and the neighbors behind the lot from flooding. Simply put, it will add nothing to our neighborhood and will only be a detriment. Any questions, please feel free to call me at a phone number. Craig R. McConnell, owner, 144 Thatcher Street, and Brandon Marble, owner, 129 Thatcher Street. And that's it.
So we had 2 different locations here, 144 and 129.
That is correct.
Okay, I only have the 144.
Both of them have signed the bottom of it, or both.
Okay, so they both want to say the same thing.
That's correct.
Okay, all right. All right, anyone else want to speak in opposition?
I see none, Mr. Chair.
Seeing none, I'm going to close that portion of the hearing. Is there any public official that wants to be heard on this issue?
I see none, Mr. Chair.
Seeing none, I'm going to close that portion of the hearing. I'm going to open it up now for discussion among the board members. Board members. Looks like we have 2 issues here tonight. We'll take 2 votes on this. One is whether or not that lot requires action by us for zoning relief. And
Hello.
the next vote would be to actually grant a variance to allow the house to be built on that lot. Is that how I'm reading that, Mr. Attorney?
Councilman McCuskey, I think he was asking you.
Oh, you know what? Something just cut out. Say
Right,
it again.
2 things here. We're looking at possibly 2 votes.
Yes.
Yes, your question is whether or not this needs to a vote of the zoning board to actually make it a lot. Secondly, it requires zoning to build a house on that lot. Is that what you're saying?
Yes. Yeah, I'm saying, one, that the old variant, the 85 variance is still in effect. And 2, we've got a variance conditions here that would merit an independent new variance.
Okay, very good. So anyway, it looks like these owners have been before the board on several occasions requesting a variance for this lot and then never built anything, and the variance ran out. And the variance section of our bylaws basically say that you have 1 year to commence construction on the lot. And if you don't, the variance will lapse. The only way you can prevent that from happening is to request a 6-month extension prior to the granted variance from expiring. And we're actually in a unique situation right now because of this COVID situation, that variances that we're granting right now, the 1 year, it keeps running until the governor declares that the COVID emergency is over, and then the time clock will then start running on all these variances. But other than that, the code is very specific that you have 1 year to commence operations on the lot. So, and secondly, the lot has to have a variance granted for the lot. In my conversations with the let's see, who was I dealing with here? When I was dealing with conservation, there is a problem with conservation on this lot that needs to be addressed. So we have to consider the situation that came before us tonight with this flooding, where there is an open trench that takes water from Thatcher Street through this lot. And the Conservation Commission has concerns and probably is going to have some restrictions put on that. So this lot also involves conservation. Anything from the board members?
Steve Bernard has his hand up, and I don't know how he did that.
Steve, you on?
It looks like he's muted.
He is, but he's on the phone, so I don't know how he did that.
I'm dealing with the phone with him. I can't see him on my screen. All right, while we are deliberating, I guess what we should...
Am I unmuted now? Hello, am I unmuted now?
Yes, we can hear you now, Steve, yes.
Okay, I'm sorry. Yes, the issue with COVID and the 1 year lapse of the variance because of non building. When COVID, when the governor put this restriction or a halt to I guess canceling variances, it had a year already lapsed?
Yes, this doesn't fall under that. Tonight.
It does fall. It falls under the COVID restriction?
If tonight we grant a variance for this, the variance will run for more than a year because of the COVID.
I see. Okay. Okay. I just wanted to be clear on whether or not it fell into the COVID classification, and you're saying it does. Okay.
This one would, yeah. Building inspector, am I correct on that?
Negative. No, the 1 year grace period of the situation with the governor is for any case that was granted prior to March 10th of 2020, but had not lapsed at that time. So that was only for prior cases prior to March 10th. After March 10th, it's the normal 1 year expiration. And the particular case that we're talking about here is well outside of that, being from the 1980s.
Okay.
So okay. The vote that we take on this tonight has a 1 year time limit. Is that what you're saying?
That's correct. If any votes you make tonight have the 1-year time limit, correct?
Okay, I didn't understand it that way. All right. So Steve, you
Okay.
get that?
Yes, and I want to make sure I understand it. This variance lapsed because it lapsed long before that March date of 2020 when the governor put the restriction on. Is
That's
that correct?
Yep, you're right.
Okay. All right. And I would think that we would I would think that this has in fact lapsed, leaning in that direction.
All right, so if we discuss that first, if that's our first consideration, a yes vote would, let's see how I want to do this now. A yes vote would.
We're in the discussion phase. Is that correct?
That's right. Yep.
Okay. So as another part of that discussion, during the presentation of counsel, did he indicate or argue that because something had been done to the lot in question, that with the intent to build on the lot, therefore we should not consider it lapsing?
I think the lot was recorded, but no building was commenced.
Okay. Yeah, I would think that it would lapse because their negligence doesn't fall within the COVID restriction.
Okay, so let's make sure we have this correct.
There's two options before us. One is to reaffirm, either reaffirm the previous grant of a variance, and if we're not enamored by that, then to request that the petitioner request another variance.
Correct. That's how I was looking at this. So a yes vote is in favor of the attorney who is saying that the variance is still in effect. A no vote says that the variance has lapsed and there is no variance on this lot. Is that correct?
As long as everybody understands the effect of their response, I suppose.
Yes vote.
You're cutting in and out, Mr. Chair.
I believe we've lost the chair again. Well, wait 2 minutes. We'll see if we can get reconnection.
Can you hear me now?
Yes.
Yeah, I lost the whole screen. Now I'm back. All right, so what we're going to do is take 2 votes. The first vote will express our concern about whether or not there should be a variance on this property. The second vote is whether or not we're actually going to grant a variance. This would be very similar to the 3 or 4 times this happened in the past with the same piece of property. So is there any discussion on this? I'm going to just make a comment on my look at this, is that the conservation needs to be addressed before we grant any variance on this piece of property. In other words, the petitioner here needs to go to conservation to get this water situation squared away, because we are getting numbers of people that are being affected supposedly by a water situation. I think that needs to be addressed and fixed before we grant any variance. But the first part is whether or not the variance is still in effect for this piece of property. So if somebody wants to make a motion, we can get moving on this, unless you got a comment.
I make a motion that, can you hear me?
Yes,
Yeah, I make a motion to grant the variance being in effect with the hopes that it fails.
all right, this is a double negative now. Okay, I see what you're saying. Somebody want to second that?
Would it serve us to clarify the motion, Mr. Chair?
Okay, yeah, a yes vote indicates you agree with the attorney that we do not need to grant a variance for this piece of property. A no vote is you disagree with him, and we do have to grant a variance for this piece of property. In other words, if you think the variance has run out, and the only way this lot can be built on is we have to grant a new variance. Is that clear to everybody?
It's clear to me. I made it.
Yeah, I mean, a yes vote means that he's going to have to be successful in getting a new variance for this piece of property. The old one ran out, is what you're saying if you say yes.
Mr. Chair, let me set the motion for you so that everybody understands. I think you confused it. A yes vote will affirm that it is still a valid 1980s variance. A no vote means you have to go to the second vote.
That's correct. Exactly. So a yes vote supports the attorney's position. Is that correct?
Yes, that is correct.
So if you think that the previous granting has run out, you need to vote no.
Call the vote.
All right, a motion's been made. Anybody second it?
I'll second.
Motion's been made and second. And the motion was to grant in the hopes that it fails, correct?
Correct.
All right. Clerk, please call the roll.
Mr. Lanus,
No.
Mr. Bernard,
No.
Mr. Pelagi,
Yes.
Chief Williams,
No.
Chairman Galligan.
No.
Mr. Chair, that's 1 in the affirmative, 4 in the negative.
Okay, so we have determined that the prior zoning has run out and he now needs to come before us requesting a new variance for this piece of property. So that's where we're at right now. Our question now is, do we want to grant a variance for this piece of property? My concern is that I think he needs to go to get this water situation squared away before he grants a variance or gets a variance. And I think that's a critical decision here on this piece of property. The water gets squared away before we give anybody the go-ahead to do anything.
I would tend to agree.
If it is procedurally correct for us to not vote, not to take the second vote at this time, I would suggest that we do that, not take the vote.
Well, he's not asking, he's asking for a vote.
Well, you just suggested that we not vote until we hear from the Conservation Commission.
Right, in other words, we're going if you think he should go to Conservation first, we're gonna deny him a variance to build a house now. At that point, he would go to Conservation, come back to Planning, and come back to us.
You should let me withdraw that. That's not fair.
I would agree with the council that we should be allowed to withdraw. Because if I may, I don't recall that this late in a proceeding that we would be asking for such a dubious vote.
Well, he has asked us for two separate votes. That's the concern that I have. The first vote is to determine whether or not the previous variance was still in effect. We have determined that it was not. So now he's asking for us to grant a variance so that he can build a house on the lot.
I know you don't like me doing this, but I can't get a building permit even if you give me a variance and I get rejected by the Concom.
Yeah, we've kind of boxed him into a situation. I know the board typically is not in favor of withdrawals, but this is a two-stage thing. And as this developed, the issue of the environmental issue, which I tend to agree with, I'm looking at a plan that's got a delineation of 2004, which has long since expired, needs some attention. So I wonder if this is one of those exceptions where we may allow the petitioner to withdraw on this second stage of this, go to conservation, which would be the smart move, and then come back and apply for variance. You know, I know the board has its rules about withdrawals, but I think this may be one of those rare cases where it fits the situation.
So far, what we have done is made it clear that this lot is not buildable unless he gets a variance.
That's right.
That's the vote we just took, that there is no outstanding variance on this lot. So your suggestion is to not take another vote on whether or not to grant or deny a variance?
Well, I don't want to put words in the counselor's mouth. I don't know. He didn't say he's asking for a withdrawal, so I don't know. I shouldn't speak.
I will give you a written withdrawal tomorrow.
All right, so here's a way we can address this. The only way we can allow anybody to withdraw is a vote of the board, because we are now into the hearing stage. We've done this before, where we were into a hearing and somebody was totally befuddled and we voted to allow them to withdraw. So we've allowed this in the past.
Yep.
So if somebody wants to make a motion to allow the petitioner to withdraw, we can take a vote on that.
Mr. Chairman, I'll make a motion to allow the petitioner to withdraw his request for variance on this lot.
And I'll second it.
Motion's been made and seconded to allow the petitioner to withdraw. Clerk, please call the roll.
Mr. Lanus,
Yes.
Mr. Bernard,
Yes.
Mr. Pelagi,
Yes.
Chief Williams,
Yes.
Chairman Galligan.
Yes.
That's a 4 in the affirmative, 0 in the negative.
Thank you.
How can it be 4? It's got to be 5.
My mistake, Mr. Chair. That's 5 in the affirmative, 0 in the negative.
I'll send an email right now. Thank you very much.
Okay, the vote is 5-0 to allow him to withdraw on the second request.
Thank you.
Okay, the next petition is 21-11, the petition of Alessandra Texeria, 54 Henry Street, Brockton, Mass, to come back to zoning after being granted, since the plans have been changed in an R1 zone located at 54 Henry Street. This is a variance. Is the petitioner ready?
Ms. Texera, that's your call.
She's muted.
She is.
Can we get her unmuted?
I've asked her to unmute, but I don't know if she can. Ms. Texera said her microphone's not working.
Did she call in on the phone?
Ms. Texera, you can call in on the phone if you wish to do that. I'll give you the phone number. It's going to be 1-929-436-2866. You must put the meeting ID and the password in when you phone call that number. One 929-436-2866. I can see you on camera, so if you need me to give you the meeting ID and password, physically give me a thumbs up. BCA, can you hide that phone number when she's in, please?
Hi, can you guys hear me? Okay.
Yeah, loud and clear.
Okay, great. Sorry about that. For whatever reason, my mic decided not to work. So thank you guys for allowing me to still speak, even though I'm having technical difficulty. So like you guys said, I went forward back last year about frontage that I needed on an addition that I was doing. There has been some change to the plans just because my life situation changed. My parents and my grandfather was recently displaced,
And in order to accommodate them, I need to add on to my property in order to fit for other people besides me and my own children. So that's what I'm asking for today. From the plan that I have, I meet all the setbacks, except that I'm 7% over the maximum area that I can use. So what I'm asking is for approval for this new plan and also to be able to go over the 7% that I'm over. Am I still there?
Yeah, you're still there.
Okay, so yeah, so that's my request.
Okay, so you actually need relief from front yard setback and side yard setback also, because this is new construction. So
Yes, so this, yeah, it's new construction because I had got approval last year when I went in front of you guys about the frontage that I needed. So that was approved. This new plan, which I'm adding on to the back of my house, it meets all of the setbacks except that it's over 7% of the maximum area of 25%.
How many bedrooms are you going to have in this house when it's done?
Altogether, then it's gonna have 7 because it's my family, which is me, my partner, my 2 kids, because I'm 5 weeks away from expecting, and then I have my parents that are displaced, along with my grandfather and my aunt. So they need three bedrooms, and then I need my own, bedroom for my family.
So can you tell us what the hardship is on this piece of property?
So I'm
What's so
sorry.
unique about this?
So the hardship that I'm facing right now, and the reason why I'm asking for this extra space, is because right now I'm in a 2-bedroom with all these people living with me. We're on top of each other. I am, like I said, I'm 5 weeks away from giving birth, and I'm sharing a room with my daughter. And then I have my grandfather, who's 94, in my dining room. I have my aunt, who's mentally disabled, in another room on the couch, and then I have my parents. If I can't get this done, then I'm either going to have to sell my house and buy somewhere else, which would probably be outside of Brockton because I can't afford anything in Brockton right now. I can't have my parents and my grandfather on the street because they end up losing their home due to when COVID happened, due to a foreclosure. So it's I am literally stuck right now without any other option except to either do this so that they all have space, or sell my house and try to find something else that will fit all of us.
So when you came before us last year, we granted you 1 additional bedroom to the left side of the house.
Right.
Now that has morphed into what is before us.
No, what the plan that I had given you guys last year was on the side of the house was going to be a bedroom, and then on top of that was going to be 2 more bedrooms. What I asked for last year was the frontage of the house that didn't meet the 30 feet. It was so that it would be aligned with the original construction of the house.
Yeah, I understand that, ma'am, but reading the judgment, what we granted you was 1 additional bedroom. And now what you're asking for tonight is more than doubling the size of your house.
Right. In order to fit all of us, that's what I would need in order to fit all of us. Because if not, again, I can't not house my, my parents and my grandfather. But at the same time, it's I'm literally in a bind right now.
Okay. Any questions from the board?
So I know this you'd already clarified this. How many bedrooms will this house be when it's built out?
So from the first plan, it was gonna have
Well, no, what you're proposing tonight. How many bedrooms are you proposing?
altogether, it would have 7 bedrooms altogether, including what's existing and what we're adding on. So it would have 7 bedrooms altogether.
So this addition that you're planning on putting on is 2 stories, a first and second floor?
So from the one from last year, the 2 story. This one, the one that I need to add for my folks, that is not a 2 story. That is just 1 level.
Okay, but the addition you're putting on in the back is 2 stories high.
The one in the back, no, sir. The one in the back is not 2 stories. On the side of the house, which is what I went for last year, that is a 2 story. But
Okay.
the one in the back, it's not, just because they can't go up and down stairs. So that is just 1 level. It doesn't even have a basement or anything. It's just a slab.
Okay, any other questions from the board? Is there anyone here, I'm going to close that portion of the hearing. Is there anyone here that wants to speak in favor?
Mr. Chairman, I'm here.
Mr. Chair, I don't see anyone other than the counselor.
Yep.
Good evening, Mr. Chair, members of the zoning board. It's nice to see you all. I hope you're all well. Your families are well. I was asked by Mrs. Texera to help her out this evening. I know Mrs. Texera to be a valuable member of this community. Her and her children do a lot to help the homeless. They, deliver meals and clothing and everything else. And I really feel bad for her situation. Like she said, she's having a child. Her family was displaced due to COVID, and she's just in a rough spot. I know she was in front of you all last year and her plans were approved. I'm not sure that the plans have changed that much. But like I said, I don't have them in front of me. But I would ask this board to really seriously consider granting her variance tonight. I just really feel bad for her situation, and she really needs our help right now. So thank you for hearing me, and good luck, Ellie. I hope this works out for you.
Thank you, Tina.
Anyone else who wants to speak in favor?
I see none, Mr. Chair.
I'm going to close that portion of the hearing. Is there anyone here that wants to speak in opposition?
I see none, Mr. Chair.
Okay, I'm going to close that portion of the hearing. I'm now going to open it up to any public official that wants to speak on the issue, other than our counselor.
I don't see any, Mr. Chair, but I do have a letter from Councilor Farwell.
Okay, you want to read that into the record?
Certainly. Mr. Chairman and members, pending before you is an application for relief to allow an addition to an existing home at 54 Henry Street. Prior approval from the board was granted, but it is my understanding a change in plans now places the proposed construction approximately 7% greater than originally proposed, necessitating relief from zoning requirements. Rarely do I provide comment to the board because decisions are always carefully considered and decisions rendered consistent with the interests of the city and an applicant. In this case, I urge you to look favorably upon the relief requested. So Liza Angela Texera is undertaking this proposed project to allow for a family member to reside in the home. This is a carefully considered proposal and would not derogate from the neighborhood. The project is not for profit, but rather to support the needs of a family member. Unless there are facts and circumstances of which I am not aware, this appears to be the perfect case for relief from our zoning requirements. As always, I thank the members for their careful consideration in all zoning matters. Councilor at Large, Winthrop Farwell Jr.
Okay, thank you. Is there any other letters that have been submitted?
None that I have, Mr. Chair, at the ready. Nothing.
I'm going to close that portion of the hearing and open up the deliberations among the board members. Board members.
Well, Mr. Chairman, a concern I would have is that in addition to her exceeding the maximum footprint for that lot, I mean, first of all, let me say I sympathize with the petitioner's plight. I truly do, but I'm just reflecting on the number of occupants that would be in that house. They were mostly adults, and while a single-family home only requires one parking space, I think, one parking space per dwelling unit in a single-family residence. I mean, with that number of adults in the house, I think that this is going to generate a lot of the need for a lot of on-street parking, which I don't think she can provide there. And going forward, I'm not sure what she's creating. You can never say never. I don't know how long she's going to be in this house if she's successful with the addition, but she's going to be creating, I should have written the number down, a 7 or a 9 bedroom house. I don't know. I have concerns about it. Anyway, thank you.
Am I allowed to answer the parking issue?
No, you're done, ma'am. Thank you.
Okay.
I have been watching this location for several weeks. The parking situation over there is deplorable. The parking on the street is 1 or 2 cars in the driveway, and that is before anything has even commenced on this house. I feel very sorry for the plight of this woman. I understand what she's trying to do, but as a board member, I have to look out for what's coming down the road in the future. 10 years from now, we could have this as a small hotel. The neighborhood over there is extremely dense, and that's one of the things that we have to look at is density within the neighborhood. And that's why we put restrictions on how much coverage can be used on a piece of property. I voted for this last year because there was going to be 1 bedroom, and in the decision it said we granted her a variance for 1 bedroom. And now she's telling us it's got 3 bedrooms, 1 down and 2 up, plus all the new bedrooms that are going out back. This is a very large addition on a very, very small lot. And my concern is the long-term effect that this is going to have on the neighborhood. I feel badly that she's got this problem, but our problem is not only to look out for her, but also to look out for the welfare of the neighborhood and the city. So I guess what she's looking for is relief from the total coverage of the property. She's looking for front yard setback to the street and also side yard setback to the south side by the porch. So some of those issues were part and parcel of the last granting of the variance, but now this is a whole new variance that affects the entire building. So there's several variance requests here, more so than just the total coverage of the lot. Any comments from the board members?
I concur with those concerns as mentioned by fellow board members.
Mr. Chairman, I'm ready to make a motion.
You're going to make a motion?
I'm ready to.
Yeah, go ahead.
I'll make a motion to grant with the hopes that it does not prevail.
Somebody want to second that?
Yeah, I'll second it.
Okay, motion's been made and seconded to grant. Clerk, please call the roll.
Mr. Lanus,
No.
Mr. Bernard,
No.
Mr. Pelagi,
No.
Chief Williams,
Yes.
Chairman Gallagher.
No.
Mr. Chair, that's 1 in the affirmative, 4 in the negative.
Okay, the vote is 1 in the affirmative, 4 in the negative. The petition fails.
Thank you.
Now, the opportunity there is to come back with a different plan other than what was presented tonight, so just keep that in mind. All right, petition number 21-12, the petition of Jose Perez, 24 Webster Road, Braintree, Mass, for a variance to install a new sign on property in an R1B zone located at 59 North Pearl Street.
How you guys doing?
Mr. Perez here?
Yes. Can you hear me?
I can hear you very well.
Awesome, awesome.
Just can't see you.
Let me turn my camera on. I apologize. There it goes. So, yeah, so I'm just trying to see if I can get a variance. I bought the building during the summer, and there was an existing sign that the electrical component, it's still in place right at the property line. So I'm trying to install a sign that's slightly wider, not slightly, I mean, it was a pole. I want to put a sign that's 4 feet wide, exactly where the old one existed. Based on some of the bylaws that I've seen, pushing it 10 feet in won't be visible when people are driving on North Pearl. But putting it where the sign has been over the last 25 plus years, I feel that it's the best use to put a sign up that's going to help my business going forward. So I'm just asking to be granted, to use what's been there for the last 25 years to put up a new sign.
All right, so there's two things at work here. One is relief from setback, which is 10 feet.
Exactly.
And the other one is you're in a residential zone, so you need a variance in order to put this commercial sign up. So you're asking for two things here.
Well, I mean, I'm in the residential zone, but I'm paying taxes as a business. So it is a mixed use. There are businesses similar to mine around me, and their existing signage is literally right on their property line. And I basically want to have, the same type of signage opportunity that everybody else has on the street.
All right, any questions from the board? I have a question. Is this going to be an LED sign?
No LED, just a standard wooden sign, 4 foot wide. And I believe on page 3, it's supposed to be 42 inches, about 3 feet high. I'm sorry, 7 feet high from the ground. So 4 foot wide by 7 feet tall. Before there was a post that, if I'm not mistaken, was about 10 feet high with a sign hanging from it. I just want to put something wider. Instead of a pole, I want to put something wider using the same, you can say, structure or footing that was there at one time. The electrical component is still there. But
When I went up and looked at that, is the electrical component right on the property line?
If I'm not mistaken, it's probably like 2 feet in.
From the property line?
From the property line, exactly.
Okay, the code says you have to be 10 feet in from the property line.
Yeah, that was there. That's been there for the last, 20 plus years since I bought the building.
It lost its grandfather non-conforming use because it's gone. That used to be an optometrist shop, and that sign was probably 18 inches by 2 feet.
Okay.
It was a very small sign.
I believe it was taller than that, but
it was taller than that. But the sign itself that hung from the post was a very small sign.
Yep. I mean, there is a picture that I attached to it the way it looked before, but yeah, you're right. Yep.
So how do you intend to light this sign?
To be honest, I mean, I was hoping to use the electrical that was there, but I mean, if I can't, I think I'm good enough with the wooden sign being up. I think there's enough lighting on the street that will give me the visibility that I'm looking for. So I don't really.
This is going to be a wooden sign that's going to be externally lighted.
Exactly. I mean, a wooden sign, and right now I don't have no plan to put any new electrical in place.
All right, so on your plan here, it says that it's 12 feet from the street.
Yep. Which it's roughly right from, I mean, if you look at, I had the surveyor put the plot plan in play.
I saw those.
What you see 12 feet in was the sign company giving me a rough idea of where it would look best from the way it was before. But if you look at the plot plan, the certified plot plan, I just want to put it right on the property line, which was where the existing one used to be.
I'm looking at a picture here that shows the driveway in the front of the house with a couple of stakes with red flags on it. Do you have that there?
Yep. Yep.
What is that stake that's next to the driveway that has the deep black cover to it? Is that the property line?
I'm looking at the picture. So is there a circle on the one you're looking at?
Yes.
Roughly, yeah.
Okay, so the white fence next door, that white fence is on the property line.
Yep.
So there's quite a bit of grass that's on the back side of that sidewalk that belongs to the city of Brockton.
According to the surveyor, yes.
Yes, correct. So my point is, that sign that was there was in some shrubbery, and it had a white picket fence in front of it, and it was there for years. It was a very innocuous sign.
Yep.
Now, all of that has been removed.
Exactly.
You're in a residential zone here, and my concern is the size of that sign and where it is located on that front yard. All the signs on that street are very innocuous signs. They're very small. Because that whole section across from the cemetery is all residential.
Well, if I'm not mistaken, and sorry to interrupt you, the signage near the set of lights, which I believe is a multiple office building, I believe that their signage is going to be, it's currently wider than
That's
what
C5. That's zone different up there.
Okay. So a few houses up is zone different?
Oh, yeah.
Okay.
That whole corner up there is C5.
Okay.
South of the cemetery is C5. Over where you are, it's residential.
Okay.
So what we have to be concerned with here is the residential flavor of that neighborhood.
Okay.
So that's why I'm asking you these questions.
Yeah, not a problem. I mean,
Okay, you're being very upfront, and I appreciate that.
Yeah. No problem.
So if that sign sits on the front lawn where you have drawn that circle,
Yes.
it is literally sitting on the property line.
Yeah, exactly. That's kind of where I would feel like I still have the visibility from people driving by. If I was to push that in, 10 feet in, it'll be so close to where the current house is that I'm using as an office. So I won't really get too much visibility when people are driving by.
Okay, so that could be your hardship. I understand that.
Yeah.
The zoning says it has to be 10 feet.
Correct.
We can
Correct.
do something for you if you request a number. All I'm saying is the city property line on North Pearl Street encompasses a good chunk of your front yard.
Sure.
So if you put your sign out where you think you want to put it, you could in fact be sitting on city property with that sign.
Sure, exactly. Yeah. I mean, I definitely want to put it on my property. I just feel that it kind of defeats the purpose if I was to put it 10 feet in and then make it 4 foot wide, like the current drawing is from the sign company. It would kind of defeat the purpose of having that sign.
All right, let me ask you this. From where you've got that circle that's drawn there, what would happen if the sign was 5 feet back from that circle?
So I'm going by the circle with the X. If it was 5 feet in from there.
Yes.
I mean, I think that's a good compromise. I would be, I think I can work with that.
Okay.
So
So
instead
it's
of
just
10
a
feet
conversation we're having now.
Yeah, yeah, of
We'll
course.
get
of course.
eventually to the board.
Yeah. I mean, I think that's a good compromise, and I think I can deal with that. But going in where you see the second, sorry, I'm just bringing it up. Where you see the X, to start there, I think it just makes it kind of too close to the house. You know what I mean?
So for conversation purposes, the circle with the X in it, that stake right there indicates the city property line, correct?
The circle with the X, if you see the post there, that's
Yeah.
where the city line, according to the plot plan, is.
Right. So my question to you is, if you were granted 5 feet of relief, so your sign was 5 feet behind where that
Exactly.
circle with the X is,
Yep.
you would still get your visibility.
If that's the only thing I can get, I think it'll be a good compromise. I
we'll leave
would
it at
love to
that.
have it right. I'm sorry. I would love to have it right on my property line, but if I can't, I think that's a good compromise.
All right. Have you finished?
Yeah. I mean, again, I wasn't aware that the business that's located right next to that satellite was a different zone. But I mean, if it is, I guess, you know, I'll be content if I can get some type of relief, not just 10 feet in.
So the other thing we got to consider here, the building inspector, do we have to grant him a relief on the size of that sign in the residential area? Mr. Plouffe, are you there?
I apologize. What was that, Mr. Chair?
On this sign that he's looking to put up, which is 4 feet wide and 3 feet high,
Yes.
No, 7 feet. I'm sorry, 7 feet high.
that's the total height of the sign.
Yep.
Okay, but the sign board itself,
Yep.
how big is the sign board? 4 feet wide?
4 feet wide, exactly. Yes.
And how high is the sign board?
From the ground up, it's going to be 7 feet, but I'm going to have 42 inches is going to be the main sign. Then I'm going to have 2 what I would call riders that are going to be 12 inches a foot wide. So it's going to be a main
42.
Yeah, so it's going to be 42, and then there's going to be 2 12s below it that I can add to if I need to.
It's going to be 5. It's going to be 5, Mr. Chairman. It looks like it's going to be 5.5 feet high by 4 feet wide.
That's the actual sign.
Yes, the sign board. He's got the main sign plus 2 inserts.
Yeah.
5.5 by 4.
Mm-hmm.
Okay, now, Mr. Building Inspector, what do we got to do with that? Is that illegal in a residential zone, or is that something you need to get concerned with?
Well, no, it's in your court. You could grant a variance based on this, but it does not meet the current requirements for signage in a residential zone.
It's too big.
Correct.
So he needs a variance on the size of the sign also.
Yes.
So he needs relief from sign setback and the size of the sign.
Yes.
Okay, now we're starting to get light shining on this thing here. And he's telling us that this sign is not going to be internally lighted. It's going to be externally lighted. It's going to be made of wood.
Correct.
Now, one of the things we have to consider, and you need to understand this on sign setback on these things, is when somebody's coming out of your driveway and they are looking to the left.
Yeah.
The reason we want this sign back there is so we don't create a blind spot so people coming out of your driveway can't see.
Oh, I understand that. Yeah, that's a good
Okay,
point.
so, all right, so now what we're saying is, you're telling us you'd be happy if you could get 5 feet of relief, and the sign is going to be no larger than 5.5 feet by 4 feet.
Correct.
And the overall height would be 7 feet.
Correct.
Okay. All right, board members, any questions from the petitioner?
I'm still, Mr. Chairman, I'm a bit confused. Is he looking as far as the subject of location? He's looking for relief from setback from the street line. Is he also looking for relief from his neighbor's lot line as well, or not?
Yes, because there's a section that we got to grant him because he's within 100 feet of a house. And
And so how close is he proposing to come to the side lot line?
I don't know, he's going to have to tell us, probably about 30 feet. If he's within 100 feet of a residential, that's 2767 double I. So
Okay,
he's got to have relief for that sign because he's in the residential area.
okay, but it looks like on his plot plan there that the proposed sign is essentially going to be in front of his own building.
Correct.
Okay,
Yes.
I just want, okay, thank you. No, I'm all set.
So I just want everybody to understand that in this conversation, this sign, the measurement for the setback begins at the city property line, not at the street.
Yeah, that's a little deceiving. A lot of
Very
people.
deceiving. So the edge of the sign is not going to be 12 feet from the street. You could have 10 feet of grass that belongs to the city. At that point, now you're going to have to go back 10 feet for the sign unless we grant him relief.
Mhm.
Does the petition understand that? Is the petitioner on?
Mr. Perez?
Yes, I'm sorry. I'm sorry. What was the question? I thought you were talking to someone else. I apologize.
No, we were just discussing among ourselves here as a question to you that only you can answer. That even though on your plot plan, you put the sign 12 feet back from the street,
Yeah.
that is not true.
Correct.
Our reference point is your property line with the city property line. Then the distance for this sign is measured from that point back toward your house.
Exactly. So if I'm looking at the plot plan like I am now, the approximate location of the proposed sign, and then the one that I think he put an arrow right where it would definitely be on my property.
Right, but what the concern, sir, is that what's misleading is, I don't know what page, you don't have your numbers page, you don't have your pages numbered, but
Yeah.
but the sign, the sheet, the page that shows 12 feet from the street, that's misleading because your graphic there is misleading to where the street line is on Pearl Street.
Yeah, I believe that the drawing was done by the sign company and he was using as a reference where the old post used to be.
Oh, that doesn't have any, that has no bearing on where the street line is.
Yeah.
So
Yeah.
you do yourself well to disregard that
Okay.
graphic.
Yeah, not a problem. Not a problem. But yeah, I mean, I would definitely be putting or using my property to put the sign in. I won't be using any city land at all
All
whatsoever.
right, can you go to the picture that says the older sign?
Yeah.
It was the very last yellow page.
Yep.
See the signpost with the sign that's gone?
Yep.
That picket fence, is that your property line right there?
The picket fence on the right-hand side or the picket fence facing the street?
The picket fence right where the sign is, parallel to the street.
Facing the street.
Yeah, both, that's my property. Well, I take it back. Based on the plot plan that was done after that picture was taken, it seemed like that the doctor was basically on city property.
Correct, that's where I'm going with this.
Yeah.
So I'm trying to get my 10-foot bearing.
Yeah.
This picket fence with the existing sign was actually sitting on city property.
Yeah. But it's no longer because it's basically been cleaned out.
Right.
Yeah.
So I just want to make sure we all understand that this picket fence with the old sign is not the reference point for the property line.
Exactly.
Okay, good.
Correct.
Wow. All right, board members, any questions?
I got a question.
Yes.
So we're looking at 17 feet from the street?
Is that about right?
Based
No.
on the plot plan, I think you are in, yeah, roughly, based on the plot plan.
There's a big difference between the street and the line of the street line. The street line is substantially back from the paved street. That's what's confusing the issue.
Usually the property line is on the backside of the sidewalk. In this case, all the posts that he put out there, the surveyor, it appears as though his property line is many feet into the grass behind the sidewalk.
Okay.
Exactly. Where the electrical component is, it seemed like that's exactly where my property line begins.
Mr. Perez, did you, when your surveyor did this plot plan, is he the one that set those bean poles there with the flags on them?
Correct.
And did he, the forward set of bean poles, did he mean to represent the street line of Pearl Street using those stakes?
Yes.
Okay.
Okay, I'm comfortable with that. Any other questions from the board? If not, I'm going to close that portion of the hearing. Is there anyone here that wants to speak in favor?
I do not see any, Mr. Chair.
I'm going to close that portion of the hearing. Is there anyone here that wants to speak in opposition?
I have one hand raised, Carol Banks.
Hi, this is Carol and Terry Banks. We're one of the abutters on North Pearl Street.
We're right on the corner.
And we just wanted to talk a little bit about the sign size. It seems to me that with the conversation that we seem to be at 5.5 feet by 4 feet. Is that correct?
So the width is 48 inches, 4 feet wide.
Okay, yeah, 5.5 by 4 feet. And are we coming, instead of the 10 foot, we're coming 5 feet from the city line towards the house?
We haven't decided that yet.
Okay,
That was just
okay.
some conversation.
My concern is the actual size of the sign itself, not the height of it, but the actual board. 4 feet by 5 feet is kind of big for the residential area. It's kind of like, you know, Dr. Ween's sign was, you know, it wasn't intrusive. It was, I don't know. It just seems that, you know, really doesn't seem appropriate for a residential. It just seems like it's like, bam, this big sign sitting there. You know, I know he wants to advertise his stuff and you know, he's a new neighbor. I don't want to, it just seems a little large, you know, to me.
Is it okay to compromise and maybe just do 36 width?
Sure.
That sounds okay to me. It's in the length of it too. It's like 5 feet. So it's actually, there's actual size to it. And then you're going to hang smaller plaques from it. Like
I want to have the option to, it's not, I mean, I want to have the option to add at least 2 in the future if I need to.
And what size are those 2 things that you're going to be hanging from it?
12. So the big one's going to be 42, which is going to be the one Exit Realty All-Stars, which is basically the office. And the smaller 2 below it will be maybe an attorney, maybe a mortgage officer, but it'll probably be 12 inches.
In width and what in, you know, width wise, they're 12 inches.
Width will be 12 inches by 40. If we go 36, it'll be 36. So
it'll be 36 on top and 36 on the bottom.
He's going to have a cumulative total signboard that's 3 feet wide.
Yep.
And it's going to be 5.5 feet high if he stays with those dimensions. 3 feet wide by 5.5 feet. That's the face of the sign, the double face sign.
Yep.
That's the signboard. And the total height from the ground is 7 feet.
Yeah, no, I understand that. I understand.
Yeah.
I guess the width, if it's 30, I don't know, what did you say? 30,
36.
You would go with 36? 36 sounds cool to me. The 5 feet, it's like, that's kind of long, high as far as, you know, it just seems big. That does. That size.
Would you look at a 3 feet by 6 feet sign overall?
At this point, I would say yes. I think it definitely is something that I can work with. So,
Yeah, I'm not concerned about how tall it is standing off the ground. I mean, because the sign's not going, the actual sign is not, the board itself is not going all the way to the ground. It's standing off the ground. I'm talking about the actual size of the
board.
the sign itself, the length, the height,
Mhm.
5 feet. I mean, that's 36 sounds cool, 3 feet wide sounds cool, but about 4 by. But
I also have discovered another question. Where
it just seems large for a
ground,
resident.
3 feet. What does that mean?
Excuse me? I'm sorry, I didn't hear the first part.
The ground, 3 feet. What does that mean?
I'm assuming that that's how they're digging down 3 feet to put the sign in.
Okay, so that's not going to sit up on top of something.
No.
Okay, so for the neighbor, you're requesting that this sign be 3 feet wide.
Yep, that sounds fine to me. And in height wise, like 4 feet would be cool. I mean, 5 feet just seems really.
Well, it's 7 feet.
No, the total
He
height.
doesn't care about, he's talking about the sign, the sign
I'm
board
talking
itself.
about the sign itself.
So with the riders, you're talking that right now is, you said 5 feet 40. Oh, no, I'm just 42, 12, 6. Yeah. I mean,
So I guess I'm saying 3 feet wide by 4 feet high. I mean, would that be a reasonable?
Are you saying 4 feet for everything?
Yeah, he
No,
wants
no.
to, yeah, that's pretty small for 3
That's
signs.
small.
No, he said 4 by 3.
Right, but the signboard, he's suggesting, the abutter is suggesting a total signboard height of 4 feet. That's pretty small for three signs.
I'm not talking.
We're not talking about the height. We're talking about the sign itself.
We're not
I
going
understand.
back.
I
The
understand.
actual height is going to be 7 feet, right?
That's
Yeah.
what he's proposing, yes.
Yep, there's no question about that. It's just asking for a reduction of the sign, the size of the sign itself, instead of 5 by 3 to potentially maybe go 4 by 3,
I know the height is still going to be.
and it's still 7 feet high.
so just to understand this correctly, and maybe the board can clarify, instead of me doing 2 panels below it, if I do 1, would that be good enough? Because
It would be are we on?
No.
It would be nice if you could actually visually see what this. Okay.
Yeah, now we see it. Yep.
yeah, so if I was to use the section that says 42 and then the section that says 12, if I was to just use that and forget about the bottom piece, that's roughly.
That's gonna bring
4.5?
it down to, that's 4.5. Isn't that
So
4.5?
if you take the bottom 12 blank one out
Yeah,
and just drop the height of the sign 1 foot,
okay. So make it, yeah, so it'll be 6 feet.
3 feet by 6 feet.
Yeah, okay.
That gives you your 42-inch sign on the top and a 12-inch signboard.
Okay.
That's 54.
That work?
Sure. That definitely works.
All right, so let me just make some notes here now. The final sign is going to be 42 by 36 and one signboard 12 by 36. The entire sign is going to be 3 feet wide by 6 feet high. Is that what you're saying?
I'm good with that.
And we have to add the width of the post, so it's, a little bit wider.
Yeah. So just to make sure that that's fine with me. So it'll be cut in half instead of maybe 10, it'll be 5 feet from my property line in then.
Well, that's something we haven't discussed yet, but
Okay.
the board will discuss that. So is the neighbor happy with that?
Yes, that sounds fine. I just out of curiosity, as far as lighting it's just going to be physically lit by what, like,
The street signs, street lights.
how is it being lit?
Right now, there is no electrical component to this sign at all.
Okay, that's cool
That's
for
not
me.
the question. How are you gonna light the sign?
I think he's saying he isn't gonna.
I mean, the way I was thinking, I know that there is some things that sometimes people add to these signs. It's just attached to the sign, but there's no electrical component off the top of my head that I'm planning on using.
What is it, like like lighting, like
Spotlight
a
thing?
light down?
Yeah,
lighting
exactly.
down
Like
onto the sign?
like
Yeah,
solar
that's-
lights that you put on the sign.
Yeah.
That's
that
cool.
they turn on.
Yeah, that's cool with me.
Mhm.
I'm very happy that it's not gonna be like a big fluorescent sign. That
No.
was a concern of mine.
No, it's not
When
gonna
we
be
first heard
like a
it was gonna
billboard.
be a sign, because, you
Yeah.
know, just looking out my window and seeing the big, you know, but no, that's fine with me. We're okay with that.
Awesome.
Thank you for listening to us and welcome to the neighborhood, Mr. Perez.
Hey, thank you. Look forward to meeting you.
Hopefully I can meet you. Haven't had a chance to yet.
Is there anyone else that wants to speak in favor?
I don't see any, Mr. Chair.
All right, is there anyone who wants to speak in opposition?
Again, I don't see any, Mr. Chair.
Seeing nobody, I'm gonna ask if there's anybody from elected officials who want to speak on the issue.
Again, nothing that I can see, Mr. Chair.
Okay, I'm gonna close that portion of the hearing, open it up for discussion from the board. Board members. I know we spent a lot of time on this sign, but this is a critical area. This is a residential area. And I think it's wise for us to indulge and make sure we get what we think we're getting.
Yep, I like the where it's, the way the discussion went. So the sign is being paired to what's in front of us right now is a sign board, the net board that's been pared down to an overall size of 3 feet wide by 4.5 feet high with a maximum height of the sign of 6 feet high. And
Right. So the overall sign, as I see it, is 3 feet by 6 feet.
Correct.
Okay, now the question is going to come, are we going to grant him any relief from the 10-foot setback?
I think we should, because it puts it much too close to the house otherwise. Make it 5 feet.
Are we here? Can you hear me?
I'll be more than happy 5 feet.
All right, what we discussed was the position of the city property line on his front lawn. And 5 feet back from that position is kind of a number we threw out there. So I'll throw that out there to start the discussion.
Okay.
We'll grant him 5 feet of relief.
I make a motion to that effect.
I'll second.
Okay, so what we're voting on now is a sign that is 3 feet by 6 feet. It is not internally lighted. And we're giving him 5 feet of relief from the city property line on his front lawn. Motion's been made and seconded to grant.
clarification, Mr. Chairman, you said 3 feet by 6 feet. 6 feet is the sign from the ground to the top of it. 6 feet is the dimension from the ground to the top of the sign. But
That's correct.
The net sign board itself is going to be 54 inches. It's going to be, the net sign board is going to be, what is it? That's 4.5 feet. The sign, the net sign board, I think it's 2 panels, it's going to be 3 feet by 4.5 feet, the sign board itself.
So the top signboard is 3 feet by 42 inches.
Exactly.
And the one under that is 3 feet by 12 inches, right?
Correct. And then that's it.
Okay.
That board?
Yep, we're good with a maximum sign, with a maximum height of 6 feet.
All right, let's put this sign to bed.
Okay.
Mr. Clark.
Mr. Lannis.
Yes.
Mr. Bernard.
Yes.
Mr. Pelagi.
Yes.
Chief Williams.
Yes.
Chair Galligan.
Yes.
Mr. Chair, that's a 5 in the affirmative, 0 in the negative.
The vote is 5 members in favor, no opposition. It is granted. with those stipulations.
Thank you, guys. Appreciate it.
Good luck.
Take care, guys.
Next petition, 1213, the petition of Anna Hulch, 65 Belmont Street, Southeast Mass, for a variance and special permit to install an electronic message board and to allow the 6.5-foot setbacks to remain in a C2 zone located at 265 North Pearl Street.
Can you guys hear me all set?
Frank Preston. Petitioner ready?
All right, is my mic working?
Yes.
Okay. Yes. All right, so I'm Anna Halleck. I am the manager at Signs by Tomorrow. I'm here representing Mr. Frank Caswell, owner of Frank's Restaurant. I'm here to request the board's approval to allow an electronic message board to be added to the existing Cardinal Plaza pylon located at 265 North Pearl Street. As you can see in the plans in front of you, the existing pylon is a bit outdated, to say the least. So we were discussing a new design with the owner, Frank. An electronic message board was brought up, but he didn't want the message board simply for the fact that it allows him to keep up with modern times. He wanted to budget in updating the entire sign, the posts, the panels at the same time, so that that overall pylon had a fresh, new, modern look, which we believe adds a positive visual impact to that general area, especially on North Pearl Street. Currently, the pylon sign area in total with the tenant panels existing is 93.75 square feet. When we decided to update the tenant panels, one, some of the businesses aren't there, and we actually don't need that many spaces. So we are updating the tenant panels, and when we add in the digital display, pending your approval, that square footage of 93.75 square feet is going to remain the same. So there will be smaller tenant panels to make room for the digital display. The reason behind this was we're not looking to add the display for an advantage over the other businesses in that district, but to use that sign area in a more effective way. This electronic message board will of course be used by the owner, Frank, for Frank's Restaurant, who is more than happy to provide a platform for the city public service announcements, but it's mainly for the businesses that are located in the Cardinal Plaza, which is where that substantial hardship comes into play. That plaza, and I'm not sure if you have the brief to the board letter that I wrote, but on that second page, you can see it's set back about 500 feet from the main road, which becomes a disadvantage to the businesses for potential walking customers, which I can personally say for my business is a huge marketing tool for us. Since we're not too good at marketing, the walking customers, that street frontage is a huge advantage for us, which the businesses in Cardinal Plaza do not have because of that 500-foot setback. Just to wrap up some information on the display itself, it is equipped with a timer, so we have the ability to set the hours during the hours of operation of Frank's Restaurant, other businesses, or whatever the board seems reasonable. It's also set with a timer in between the messages that will be displayed. We generally like to set it around 30 seconds. That way it doesn't cause any distraction to drivers. And I'm not sure if you've seen other digital displays in other towns, but sometimes the displays are almost blinding at night, which really defeats the purpose of them. So we personally only work with Dektronics, not only because of the quality of their displays, but it's also equipped with a dimmer. So for the illumination, it automatically will adjust itself based on the natural light around it. And you can also dim it and customize in the settings on your laptop yourself. Lastly, we are also going to request the board's relief to keep the existing setback of 6.5 feet so we can utilize the beautiful wooden posts that are existing. So with that being said, if you need me to go into further detail on anything, or if I can answer any other questions. I don't know if I'm hearing you.
Ken, I think you're muted.
Okay, did it work then? Okay, I can hear you guys now. Sorry.
Ken, you're muted.
How's that? Can you hear me now?
Better.
Yep,
Okay, I don't know what happened there, but I just want you to understand that one of the concerns this board has is we do not want animation on these signs.
Nope, no
All those
animation.
things jumping all over the sign. It's a distraction. There's 4 lanes of traffic up there, and I'll tell you, this can become a big distraction.
As a sign company owner, I agree with you. It's only going to be used for words, no animations, no moving lights, anything like that. Is just a still message for at least 30 seconds.
Okay, so you're okay with 30 seconds between changes.
Yep, absolutely.
All right. And the other thing that I went up and looked at this, and we got to be careful that coming out of this driveway, you can look to the right. I think with the setback, the sign is far enough back so you can see to the right. But that's one of the things that you want to be careful of underneath this digital board, that remains so that somebody can see through there.
Yep, that's another reason we had a very long design process with Frank. We wanted to keep the square footage the same so that we weren't just adding a digital display underneath what's existing. We're updating the actual tenant panels. So after it's all said and done, refreshed, painted, that square footage is going to be exactly the same. So there's nothing that's going to be extended below anything or above.
So these signs are usually on while the business is open.
That's correct.
Okay, that's what the code says, so that you're not, that's what it's going to be.
Yep, and that would be based off of Frank's restaurant, not the Cardinal Plaza.
Okay. And I have to write the decision on this, and one of the things I'm going to be specific about is the dimmer, that during the night that this is dimmed. So if I put in there about national standards for the intensity of LEDs at night, you would understand what I'm trying to say.
Yep, which is why we work directly with Dektronics, because they have the ability to do that. And it's all through your phone. So if there were any complaints, even if Frank or us were in the Bahamas, you can still fix it through your phone as long as you have Wi-Fi. So it's very easily customizable.
Okay, very good. Any other questions from board members? How is the sign going to be lighted from those 2 lights that we see down below?
For those ones, no, we're actually going to be replacing those lights. So instead of the lights coming from below where the digital display is, because we don't want any light shining on there, we're going to be putting new gooseneck lighting on the top area of the sign, shining down on the tenant panels. And there's enough distance between the top of the sign to where that digital display is, where that's not going to affect it.
So these will not be internally lighted?
The tenant panels?
Yes.
That's correct. We're actually going, before we were going to just repaint them, but because of the sizing and the investment we're putting into this signage, we're actually going to be doing V-grooved, which is pretty much a look like a wood carved sign, but they will not be internally illuminated. They're going to be, each tenant panel will have a wood carved sign for itself.
Very good, thank you. Any other questions from any board members? Not, I'm going to close that portion of the hearing, open it up for discussion with anyone who wants to speak in favor.
I see none, Mr. Chair.
I'm going to close that portion of the hearing. Is there anyone who wants to speak in opposition?
I see none, Mr. Chair.
Is there any public official who wants to be heard on this issue?
I see none, Mr. Chair.
Okay, I'm going to close that portion of the hearing. I'm going to open up for deliberation from the board members.
Mr. Chairman, I'll make a motion to grant.
Okay, on the motion, there's a couple of things we want to include here, which is the timer, the 30 seconds, the intensity, the dimmer, the setback of 6.5 feet, no animation. Everybody good with that?
Yes.
Okay, somebody want to second that?
Second.
Motion has been made and seconded to grant with those stipulations. Will the clerk please call the roll?
Mr. Lannis. Mr. Lannis?
Sorry, yes.
Mr. Bernard? Mr. Bernard?
Yes.
Is that a yes to the question or asking? Is that an affirmative vote, Mr. Bernard?
Yes, you hear me? Yes.
Okay. Mr. Pelagi?
Yes.
Chief Williams?
Yes.
Chair Galligan?
Yes.
Mr. Chair, that's 5 in the affirmative, 0 in the negative.
Okay, the vote is 5 in the affirmative, none in the negative. The petition is granted.
Awesome. Thank you so much for your time.
Good luck. Petition 2114 was withdrawn. 2115, the petition of Kenneth Patel, care of Nezarella, 1063 North Main Street, Brockton, Mass, for a variance from section 2732 and 2710 to allow expansion greater than 50% of the existing building in a C5 zone located at 516 Pleasant Street. Attorney Nezarella.
Good evening, Mr. Chairman. Good evening, members of the board. And with your permission, my presentation is as follows. With me this evening is Mr. Patel, the owner of the establishment, together with Bob Rigo, who is an engineer with Skyhawk Engineering, Riverhawk Engineering. This establishment we'll be discussing this evening is located on the corner of Pleasant Street and Wheeler Avenue. It's been a commercial entity for years and years and years. In fact, at one point in time, that whole area was of commercial entity prior to the city in its wisdom converting it to a C2, C5 office, general office use. I can remember not far back, there were many restaurants there, Gary's Restaurant on the corner of Pleasant. In Moraine Street, there was the Freight House. There were several gas stations. There currently is a donut shop, laundromats. So much of it is of a commercial nature. This business has been there, I believe it was a gas station prior to being what it is now. Mr. Patel purchased the store from the prior owner a couple of years ago. And it was somewhat of a sleepily run organization. And I think most will agree of a nondescript aesthetic picture. It's got that, it's a white building with the sign that says beer and wine. Mr. Patel's ambition was to expand his product and service the neighborhood that was looking for that product. He became successful and his business commenced growing. He has since come to the belief that an expansion of his business would serve both the public in the general area in which it exists. His goal is to take the existing building and use that for storage and warehousing and add an additional building, which will be the store. That will accomplish a couple of things. The warehousing will diminish and cut down on the frequency of deliveries and trucks going in and out of the place. They'll contain all their storage right on site. Secondly, he will be expending a significant amount of money in this new building, which you will see, I believe is not arguable that it is of high aesthetic value, and it will, I think, bring an aesthetic increase to the area and make a Route 27, an entity on Route 27, look as though we would like it to look. Now, the unique and I would suggest favorable aspect of this petition, it sits on a lot of land that is double the size of what is required. We need about 10,000 square foot area lot size. We have 27,000 square feet. There is no relief being sought for setback, sideline, or front yard. The only relief is what I had picked up on the plan of the existing building, that its rear yard setback was shot about 1.5 feet. So even though that building is up, I'm going to be asking the board to address that. So in the future, if we need to refinance, that we won't have an issue with the bank examiner or looking at his plot plan and saying we need relief. I'd rather get it done now. Other than that, we are basically expanding a non-conforming use. And I think, as the board is well aware, and from some previous statements earlier this evening, unless there is a finding that that expansion would be detrimental to the surrounding neighborhood, then the board would be inclined and would have good cause and reason to grant the request. So I will turn this over to Mr. Rigo, who would like to do an overview of the plans. Bob? We're not hearing you. You're muted. You got to go off mute.
I apologize. I apologize. For the record, my name is Bob Rigo. I'm with Riverhawk Environmental. We're the civil engineers for the project. And as discussed, we're looking to help out Mr. Patel expand his store by adding basically a 3,105 square foot addition to the existing structure that's on site. Currently, the property is serviced by 3 curb cuts. 2 of the curb cuts come off Pleasant Street, and 1 comes off Wheeler Avenue. To accommodate, the additional parking that we're proposing, which will be 22 spaces total, we're proposing to close off the curb cut to Wheeler Street, which that curb cut is very close to the intersection at Wheeler Street. So it kind of would eliminate some traffic conflicts on that side of the site, and then allow for the 22 spaces to be incorporated around the site, along with the 2 ADA handicapped accessible parking spaces on the front portion of the property. In doing that, expanding it, we're proposing to handle the stormwater on site, add some additional catch basins and infiltration areas to treat some of the stormwater that's generated on the property. Currently, all this stuff flows off-site without treatment or control. And we're proposing to kind of enhance the greenery kind of substantially around the perimeter of the site, particularly along Pleasant Street, and kind of enhance the screening effect along the abutting property to the west by the addition of some decorative trees, shrubs, and annual plants along both the front and then along the side of the abutting property. And then the remainder of the property now, which is currently just a grassed area, again, would just be maintained as pervious grass area. And that results basically in about 39% open space on the site, well above the 10% requirement. That's all.
So before, Mr. Chairman, the board makes inquiry, I would just like to make one final note. I think I have to, and it's about this Patel family. They are not novices or newcomers in the business world. They are extremely talented, hardworking, and have created very high value to the business that they have opened up, and they intend to do that with this business as well. So for those reasons, again, I think it hopefully persuades this board to grant the relief, allowing the extension of the non-conforming use. With that, if there are any questions, we'll be happy to respond.
What's the hardship on this, Phil?
Well, quite frankly, I apply, and most of the times I apply for the upper level hardship variance but it does not require a variance. This requires an extension of a non-conforming use because it's a non-conforming use. So it is a 48, section 6. One can always apply for the upper level and request something lower than that. You can't do the reverse. You can't ask for something less, like for instance, a special permitted use, and then increase it to a variance, because the notification requirement has been there and people are already aware of what you're looking for. So I would ask the board to look at this as an extension of a non-conforming use and grant based on the chapter 48, section 6, whereby they grant because they make a finding that there is no greater detriment to the surrounding neighborhood than would already exist. Aside from the fact, and not to get into historical areas, it's always somewhat of an irony when you have an area that's all commercial, the city changes it, now you're fighting for reasons as to why you want to continue your business and expand it. So that's always been this circular conundrum, if so to speak. But I would leave it with the board to look at this as a 48, section 6.
Okay.
I had one question, Mr. Chairman. Counselor, so just for clarification, your proposed addition doesn't require any yard setback relief.
That is correct.
So, but the existing building, which likely predated zoning, or it's grandfathered at this point in any case, you're looking for relief from the setback from the existing building?
Yes. I wanted to clear up the record. Again, if they wanted to go for bank refinance or any other type of action like that, that would require a clean slate.
Okay. Yeah, I guess that's, yeah.
So where is that location?
That's on the rear of the building. It says 15.3, and you'll see 23.4 from the edge of the building to the lot line, and 25 feet are required. They have 23.4. Next to the dumpster.
And how long has the existing building been there? In its current form, that's got to be decades. That's the old Warren, wasn't that the old Warren service?
Warren's gas station.
Yeah. So that I mean, the 23.4, that's an existing non-conforming. That's excused by, I forget where it is in the
Well,
zone.
the statute that says after 10 years, the building inspector is barred from taking any adverse action against it. But again, while I'm here, I thought I would just clean everything up on paper.
I got it. Thank you.
So many years ago, this came before us on zoning when it was Warren's Esso, and it was granted a variance to be a neighborhood store. And then after it was in there for a couple of years, they applied for beer and wine, or beer, whatever it was. So this started out as a neighborhood store. That's what was granted to go in there. So that's the history of, from the gas station that sat there vacant for a number of years, that this property was purchased. It's in a C5 zone, and it was granted to be a neighborhood store. Now, the way I'm looking at this is the addition can't be more than 50% of the original building size. This is 3 times the size of the original building. So that we have to consider.
Correct.
Okay, I just want you to realize that according to zoning, in a non-conforming, which this is because it's C5, that addition can only be half the size of the original building.
Unless you grant the variance,
unless we grant the variance, that's
which
correct.
I'd be prepared to speak on. And again, I think the part of the hardship, and I'm well aware of the aspects of a hardship being related to soil topography and what have you, the hardship that many businesses in the city of Brockton like this face is that they were operating for years and developed their businesses and spent their money under one particular zone. Without petition by their own end, the city went and changed the zone. And so now to make it a hardship is almost literally sometimes impossible to prove there's an issue with the soil, the shape of the land, the size of the land. In this particular petition, one could arguably state that it is not a square, and you could talk about the shape of the land, which compels the proposed addition to have to exist where it does exist. But I don't think there's a question that granting a hardship in this particular aspect would enhance this whole development, this whole area. But Chief, and I think we may have had discussions like this in the past. It is oftentimes literally impossible to find a true hardship in some of the circumstances where the city's gone in and changed the complexion of the horse and asked, how do you get it back to the same color again? It's very difficult.
I understand what you're saying. I just want you to realize that these petitioners that are before us tonight were not harmed by the city changing the zoning in this particular locus. They came after the zoning was done. When they purchased this property, they knew what they were buying, correct?
That's absolutely correct. What the harm, if we want to call it harm, is they're somewhat handcuffed from developing the business. And that's what business people try to do. They try to increase and develop and expand their business to make it better.
Correct. I understand that. And when the authors of the city zoning put this thing together, they decided that in a C5 zone like this, they would allow an existing occupant of that piece of property to expand in a similar fashion, but not to exceed 50% of the original size of the building. That's what the ordinance says. That's all I'm.
Correct.
I just want you to be aware of what I'm going through here.
To balance off the seesaw, here we have 30,000 square feet of land. We have an awful lot of land, and this still doesn't infringe on any of the sidelines, the front lines. It doesn't affect the picture of this by making a footprint, an extended footprint, look like it's somewhat awkward because you have such an excessive amount of land that you can build here. And I think, part of zoning is to create the highest and best use for the property as well.
So your intention is to take the original store and convert that into a warehouse?
For storage, not a warehouse, but for
storage building.
Product, correct.
All right, so now you're going to change the use of that building from neighborhood commercial to storage. And I don't see any loading area here for trucks at all. How do all these beer and wine trucks come in and make deliveries here?
Well, they would either come off Pleasant Street or come in through Wheeler Avenue.
You can't come in Wheeler Avenue because it's closed off.
Well, we come in Pleasant Street and go to the rear of the building.
I don't know how you're going to get there. It's not shown on the plan. Just an observation.
No.
Okay, any other questions from any board members? Board members are good? I'm going to close that portion of the hearing, opens up to public discussion. Is there anyone here that wants to speak in favor?
I see none, Mr. Chair.
Okay, I'm going to close that portion of the hearing. Is there anyone here that wants to speak in opposition?
I see none, Mr. Chair.
I'm going to close that portion of the hearing. Is there any public official that wants to be heard on the issue?
I see none, Mr. Chair, but I do have a letter, I do have an email in support.
Okay.
Can I read into the record?
Sure.
Dear ZBA board members, I am a longtime owner of the property at 530 Pleasant Street, a mixed-use 3-story dwelling housing residential tenants in my real estate office. I would not object to any expansion of the building at 516 Pleasant Street as long as a fence is erected and maintained along the back side and westerly side of 516 Pleasant Street property line. This fence would prevent any foot traffic via the abutting properties. Sincerely, Peter Gigantis, Gigantis Realty, 530 Pleasant Street.
I think in the last determination, we made that a stipulation. That fence had to go up. Is there a fence there now, Phil?
I am not aware of one.
If I may,
Yeah, go ahead.
There's a fence along the southerly boundary and a portion of that going down the westerly side, but it does stop kind of at the rear, where the rear section of the building stops. So it extends maybe about 100 feet, about 30 feet of the 120 feet along
Right.
the line.
Who is the petitioner who wrote this letter? What street number, Pleasant Street?
It was the next address up at
530.
530.
Plan shows 528 being the house next door.
Well, Gigantus is the one after him.
Would be where Freddie McKinney's office was.
He's an abutter to an abutter.
Right, so he doesn't abut this property.
No.
Okay. All right, board members, any discussion?
Well, one of the things I'm impressed with is the architectural plan. I like the way they're going to incorporate a new look. If I'm reading the plan correctly, they're going to incorporate a new image to the old and the new, making it. They're going to freshen up the appearance from the street to give it a complete new look. Is that correct, Bill?
That's correct. A completely new look. And we would also adhere to the building inspector's recommendations about loading docks, what have you.
All right, I need to interrupt because this conversation now is just between the board members.
Correct. I was just responding to this question.
Did we establish, Mr. Chair, how many permanent employees will be in the building?
Nothing was said about that. There was a stipulation with the other building that there had to be 2 employees on duty at all times. I think this store is so big, you're gonna have to have at least 2. If you want to make that a stipulation that there has to be at least 2, I would put that in.
Well, I think it's a. I think it's as well designed as you're going to get for an existing piece of property there. It looks attractive, at least on the design plan.
Yeah.
What about the green space that we saw there? I know that in the past, I go by this place every day, and after we told them they had to put up granite edge stone, and it just went on and on and on, and it didn't get done. Finally, it got done. Landscaping was minimal. It was not anywhere near what we asked for. When I went up there today, I noticed they had planted a couple of green trees out front, and the tags were still on them from the store where they bought them. Quite honestly, the cooperation that we got from whoever owned this place was not good. We asked for green space, we asked for things to be done up there, nothing got done until they came looking for something, and now they've planted a couple of trees in the snowbank. So I'm just expressing my concern that if this is granted, what we're seeing on here for green space and trees is what we expect to see.
Well, doesn't this have to go to just by the size of the addition? This has got to go to site plan review, tech review.
Well, if it does, I hope they bring that up.
Yeah, I think it's a very aggressive plan. It's we've come quite a ways from the arguments of the neighbors on Wheeler Street and what was going to go in there after the gas station had been vacant for so many years. But so they're calling on us to agree that it's the highest and best use, but we have to step out on faith that as the chief said, they're going to. Steve Bernard trying to speak.
Oh, I'm sorry, Steve. I couldn't understand you. Yep, go ahead.
Okay, I'll start again. This is quite an aggressive plan, and a long way from the discussions that we used to have with the neighbors on Wheeler Street about what was going to go in after the gas station. But I do agree that this piece of property could use some freshening, and it's a very important segue to the city. I'm only hoping that, as you said, Chief, that they will respond properly to the design that they've submitted. There's a lot of feedback on my phone. Is everybody hearing me?
Yeah, I hear you good.
I can hear you.
Okay. Thanks a lot.
Any other discussion from the board? If not, I'll entertain a motion.
Motion to grant.
Oh, can you be a little more specific?
Yeah, well, you can add stipulations. I'd like to see it granted, but I'll certainly accept stipulations from other board members.
So we're granting relief to expand greater than 50%. And we are also granting relief on rear yard setback on that 23.4 feet.
Yes.
And did you have, Mr. Chairman, did you suggest some stipulations for vegetation?
Well, no, I guess I just expressed my frustration that what we had agreed to a couple of years ago reluctantly got done with a flower here and a flower there. It was just, it wasn't pretty. So.
Sorry to interrupt. I'm withdrawing my motion to grant.
Well,
Somebody want to make a motion?
in that case, I'll make a motion to grant relief on rear yard setback and also the cap on the maximum percentage of addition.
Right, greater than the 50%.
Greater than the 50%.
I'll second.
Okay, motion's been made and seconded to grant with those stipulations. Clerk will please call the roll.
Mr. Lannis,
Yes.
Mr. Bernard,
Yes.
Mr. Pelagi,
Yes.
Chief Williams. Chief Williams,
Yes.
Chair Galligan.
No.
Mr. Chair, that's 4 in the affirmative, 1 in the negative.
Okay, the vote is 4 in the affirmative, 1 in the negative. The petition is granted.
Nice. Thank you very much, Chairman.
Okay, the last case of the evening, 2116. Petition of Rudely Gustama, 598 Pleasant Street, Brockton, Mass. For a variance from section 2739 and 2710 to extend a non-conforming use by greater than 50% for the addition of a second floor, creating a two-family in a C2 zone located at 598 Pleasant Street.
Good evening, Mr. Chairman, members of the board, Philip Nasrallah for the record. And on this petition with me, I believe Mr. Gustama is listening in, but also Scott Farrier from JK Holmgren Engineering is with us as well.
Phil, could you speak a little closer so we can hear you? We can't hear you very well.
I'm sorry. I was saying that Mr. Scott Farrier from JK Holmgren Engineering is with us this evening on this proposal. For purposes of location, this property is at the beginning of Pleasant Street, well, the corner of Pleasant West, right behind Walgreens. And if one were to look at this property, it gives you an initial sense of what the estate houses looked like in Brockton 100 years ago when we had the shoe factory barons. It's a massive piece of land, and you can barely see the house set back. It doesn't encroach any of the sidelines, rear yard setbacks, what have you. Mr. Gustama, the owner of the property, commenced building an addition to the first floor, and in order to incorporate other extended family members in the house, he decided halfway through that he wanted to make it into a two-family. So that's the reason that we're here this evening, because of that reason. The property is, although we are expanding greater than 50%, we are not extending or expanding the footprint, which I think is important. So we are just basically going up, except for one small area that we go out in the back. Looking from the street or even from the side of the land, one would not even think we expanded at all. In fact, for those of you who remember the word the Ponderosa, it almost looks like the Ponderosa. It's such a big lot there. Scott, if you'd like to take over and go into any details.
Sure. Thank you, Phil. I think the only thing to add to that, Mr. Chairman, is as it's proposed to be a two-family, we do have parking, existing parking on site to the left of the building. There are room for 6 parking spaces, plenty of room to turn around, so that there is ample parking for the multifamily use. As Attorney Nezarella said, all of the other setbacks, even though we're in a commercial zone, all of your typical setbacks for residential uses are available on lot. We have about a 60-foot setback in the front and the rear and 30 feet to the side. So there's plenty of buffer to all the properties, Mr. Chair.
I'd like to add in one interesting note for the board to consider, because I know we always try to touch base with either the extension of the non-conforming use, or if we're going beyond 50%, what is the hardship? But this is, the city again changed this to a commercial zone. By right, there is an opportunity if we wanted to have a guest house, a hotel, a rooming house there, but yet, again, the contradiction is to have a second story on your residence. It becomes somewhat of a more ambitious proposal we have to make. And that's sometimes the difficulty when we take zones that were years ago residential and we go diametrically opposite that and make them into commercial. So that's somewhat of an inbred type of problem we have in the city of Brockton. As we all know, it's the whole city spot zoned, and it makes it very difficult to find rationale other than common sense for the proposals we come before the board with.
Any comments, questions from the board? My investigation with the city records indicates that this is a two-family house already. It has been a two-family for years. It's been taxed as a two-family. The records indicate that there's a 4-room apartment on the first floor and a 4-room apartment on the second floor. So it's already been a two-family. So what's before us tonight is an expansion of non-conforming use. Also, in my checking at the building department, we cannot find any building permits that were pulled to put that addition on the back of the building. It was all built without permits, according to my investigation.
I did not participate in that part of the activity, nor was I representing the homeowner at the time. So how that came about, I don't know, but hopefully this action here this evening will be corrective of everything and try to clean that record up.
Well, if this is a two-family already, and it's a 4-room apartment on the first floor and a 4-room apartment on the second floor, this is obviously morphing into something very much larger than a 4-room apartment. And who knows whether it's going to be a two-family when we're done here. But I guess that's my point, that if somebody has been deceptive here and put on a whole first floor addition and never pulled any building permits for it, what was the intention of whoever was doing this work? Yeah. That's what bothers me, Phil, that, you know, it is a two-family, it's 4 rooms, it is what it is. But this is what we're up against here, is things that are being done illegally, and then they're coming back to zoning and saying, "Whoops, can you help us out here?" And I'm just a little bit frustrated that this building, when I went up and looked at it, if it is completed in the form that they're showing, this is going to be one very, very large building. So that's all I got to say.
Well, if I may respond to that, Mr. Chairman, the expansion would be an expansion, would be larger. But again, based upon that footprint, I don't think it shows as any significant bump in the road by that expansion. Secondly, I don't know the reasons why or what knowledge he had or didn't have when he made the extension without permission. There are remedies for that. The city has a right to sanction, but his only recourse is to come back before the board and say, now I would like permission, do it the right way. I don't think the board should act as a penalty box and penalize him for that. There are avenues within the city, in enforcement, et cetera, that can handle that and address it. But his only remedy to get this the right way is to come back before this board. And I believe
correct. And I am not saying that this board is acting in that fashion, Phil. I'm just saying that according to the city regulations, this can only be expanded no more than 50%. And there's a reason why the forefathers put that in. And that's what I'm mentioning here tonight, that apparently this two-story, four-room apartment building, when we look at density, is going to be quite a bit larger than what it originally was. And did our forefathers say it can't go more than 50% for a specific reason? I think they did. So that's the mountain we have to climb here, and that's what you're asking, is to get relief from that 50%.
right. And I think that's a point well taken, Chief, but I also think our forefathers were dealing with properties a lot smaller than what we deal with today. So this is more parallel to what's going on in 2021 than it was way back when these structures were built. I would ask just to take that into consideration.
All right, is there any other questions from any board members?
Can I ask Scott a question?
Sure.
Scott, I'm just curious about the parking spaces. Why is like 5 and 6 so askew?
Just because the existing parking lot, it kind of has that little bit of an angle into it, Chief. So just to try to keep them perpendicular to the head of the pavement, basically.
Just looking at the plan real quick, it looked like it would be tough to get in and out of space number 6.
Sure.
You could straighten those lines out, though. It looks like you've got the room to straighten them out.
Yes, Scott. What is between spot 4 and 5? There's that V there.
Just paving. It's not landscaping. It's just paving. It was just to keep things perpendicular to the edge of parking, and then 6 would just back straight out towards the building and have room to then turn to head back to Pleasant Street.
Okay, thank you.
Thank you.
Any other questions from any board members? No, I'm going to close that portion of the hearing. Is there anyone here that wants to speak in favor?
None that I see, Mr. Chair.
Okay, I'm going to close that portion of the hearing. Is there anyone here that wants to speak in opposition?
No one here, Mr. Chair, but I do have a letter in opposition.
Okay, I'll have you read the letter.
All right, well, everybody sit down and have dinner because this is long.
Well, Tony, yeah, go ahead.
Dear Mr. Galligan, I am writing in regard, this is from William Morgan at 14 Pennsylvania Ave, Brockton, Mass. 02301. I am writing in regard to the meeting of the Zoning Board of Appeals on February 9th, 2021, pertaining to the petition of Rudley Gastama, 598 Pleasant Street, Brockton, Mass., for variance allowing for a 2-family in a C2 zone. My name is William Morgan. I've lived at 14 Pennsylvania Ave, Brockton for 29 years. I oppose granting this variance. To grant a variance in accordance with Article 7, Section 2748, the board must find that all of the following 4 conditions exist. 1, the variance can be granted owing to the circumstances relating to the soil conditions, shape, or topography of land or structures, and especially affecting such land or structures, but not affecting generally the zoning district. The house at 598 Pleasant Street was built in 1925. The residential house predates the C2 zoning assignment. At some point, the 8-room, 2-bath house apparently became a duplex. There's been no change to the soil conditions, shape, or topography of the lot that would justify a variance. If you find that there is, please read your finding into the record at this time. Dramatic pause. 2, a literal enforcement of the provisions of the ordinance would involve substantial hardship. Again, the house was built in 1925. For 96 years, it has existed as it is. Like my own house, it may be in need of repair, remodeling, or update, but the age itself is no cause for hardship caused by the zoning ordinance that would justify a variance. If you find there is, please read your finding into the record. 3, the variance may be granted without substantial detriment to the public good. 4, the variance may be granted without nullifying or substantially derogating from the intent or purpose of such ordinance. Zoning laws and ordinances are intended to protect an existing neighborhood from overcrowding. What argument can be made that adding another residence on an existing lot would not result in crowding? Increasing the number of residences on the same amount of the property is the definition of crowding. If you find there is no crowding, please read into the record at this time. All 4 of the requirements have not been met. In accordance with Article 7, Section 2748, the board can't lawfully grant a variance. Sincerely yours, William Morgan. The end.
Okay, thank you. Is there anyone else that wants to be recorded in opposition?
None that I see that, Mr. Chair.
I'm going to close that portion of the hearing. Is there any public official that wants to be heard on the issue?
None that I see, Mr. Chair.
I'm going to close that portion of the hearing. I'm now going to open it up for discussion among the board members.
Mr. Chairman, for clarification, did you say that your research revealed that it's a legal 2-family at this time?
Yes, that's how the assessors have carried this property for years.
Okay, so they want to expand a legal 2-family. They're not introducing. They're not making it bigger than. They're not increasing the number of families. It's an existing 2-family.
I don't know if the petitioner actually knows that it's a 2-family, because the request is to make it into a 2-family. What I'm saying is the city records at the assessor's office already carry it as a 2-family. I don't know why they would be asking to make it a 2-family.
That's confusing.
Mr. Chair, may I add something in as inspector?
Yes.
There had been a building permit applied for our office, and I have denied it. And I gave you a copy of that denial. The records of the city indicated that when it was built as a 2-family. Now, zoning regulations allow you to maintain a nonconformity, but if you abandon that nonconformity, it reverts back to a conforming use. If the 2-family was abandoned to a 1-family, at some point, that 1-family would then stay as a 1-family, but could not go back to a 2-family without a variance. So if the owners had gone back to 1-family, then you would have to grant a variance to allow it back to a 2.
So could it happen that it went to a 1 and one city agency didn't know that it had gone back to a 1, so they kept it as a 2?
That is correct. It's possible.
Okay.
Well, I mean, one of the, from the positive side of the discussion, I mean, at least the property is roughly 25,000 square feet, which is dramatically in excess of what they need for a 2-family. That's one encouraging thing. And the next thing is that they're up against the commercial, they're up against the Walgreens, and they're set back from the street 62 feet. So they're not exactly crowding any of the abutters. We don't see that. We don't see a case like that often.
So anybody want to make a motion?
I'll make a motion to grant.
Second.
Motion has been made and seconded to grant. Will the clerk please call the roll?
Mr. Lanus.
Yes.
Mr. Bernard. Mr. Bernard.
On mute, I believe.
No. No.
No. Okay. Mr. Pelagi.
Yes.
Chief Williams.
Yes.
Chairman Galligan.
No.
Mr. Chair, that's 3 in the affirmative and 2 in the negative.
3 in the affirmative, 2 in the negative, the petition fails. That is it for this evening, guys. I think.
Thank you.
That's the last one.
Okay.
Thank you.
Thank you, BCA. We're all set.